ప్రాథమిక హక్కులు. It is a very important topic in Constitution, and we would be expecting many questions from these areas. ఫండమెంటల్ రైట్స్ అనేది చాలా ఇంపార్టెంట్ టాపిక్ ఎగ్జామ్ పాయింట్ ఆఫ్ వ్యూలో. అది యూపీసీ కానివ్వండి, స్టేట్ సర్వీసెస్ కానివ్వండి, ఏ బ్యాంకింగ్ ఎగ్జామ్కైనా, ఏ కాంపిటేటివ్ ఎగ్జామ్స్కైనా, జనరల్ స్టడీస్లో, ఇండియన్ పాలిటీలో ఫండమెంటల్ రైట్స్ నుంచి మేజర్ క్వశ్చన్స్ మనకు కనిపిస్తుంటాయి. And it is also one of the area where we could get confused easily. Reason being, we have to remember most of the articles, and every single article in fundamental rights are such a clause that we would be easily carried away, or we would land in answering wrong questions. So here one need to understand the basic concepts of fundamental rights. One have to compare one fundamental right with other fundamental right, and if possible one have to remember all those articles, very important articles which we generally see in question papers. So ఈ ప్రాథమిక హక్కులు అనేది మన కాన్స్టిట్యూషన్లో చాలా ఇంపార్టెంట్ పార్ట్, and we would be dealing today what fundamental rights are, introduction, basic features of fundamental rights, and we would just carry on with our classes on fundamental rights. So what are fundamental rights? See, we have two words here. One is fundamental and rights. So why we call this section as fundamental rights? See, one thing is we call it as fundamental because these rights, the rights which are in part 3 of the Constitution, these rights are guaranteed by our Constitution. Fundamental rights are guaranteed by our Constitution, and as we know, our Constitution is fundamental law of the land. Because Constitution is the fundamental law of the land, and the same Constitution guarantees rights. That is the reason why I call them as a fundamental right. That is one view, one approach. The other being, we also call these as fundamental rights because these rights enshrined in the Constitution will enhance or will help each individual or every citizen of the nation to develop their overall personality, be it material, be it in today's our topic is fundamental rights, ప్రాథమిక హక్కులు. It is a very important topic in Constitution, and we would be expecting many questions from these areas. ఫండమెంటల్ రైట్స్ అనేది చాలా ఇంపార్టెంట్ టాపిక్ ఎగ్జామ్ పాయింట్ ఆఫ్ వ్యూలో. అది యూపీసీ కానివ్వండి, స్టేట్ సర్వీసెస్ కానివ్వండి, ఏ బ్యాంకింగ్ ఎగ్జామ్కైనా, ఏ కాంపిటేటివ్ ఎగ్జామ్స్కైనా, జనరల్ స్టడీస్లో, ఇండియన్ పాలిటీలో ఫండమెంటల్ రైట్స్ నుంచి మేజర్ క్వశ్చన్స్ మనకు కనిపిస్తుంటాయి. అండ్ ఇట్ ఈస్ ఆల్సో వన్ ఆఫ్ ద ఏరియా వేర్ we could get confused easily. Reason being, we have to remember most of the articles, and every single article in fundamental rights are such a clause that we would be easily carried away, or we would land in answering wrong questions. So here one need to understand the basic concepts of fundamental rights. One have to compare one fundamental right with other fundamental right, and if possible one have to remember all those articles, very important articles which we generally see in question papers. So ఈ ప్రాథమిక హక్కులు అనేది మన కాన్స్టిట్యూషన్లో చాలా ఇంపార్టెంట్ పార్ట్, and we would be dealing today what fundamental rights are, introduction, basic features of fundamental rights, and we would just carry on with our classes on fundamental rights. So what are fundamental rights? See, we have two words here. One is fundamental and rights. So why we call this section as fundamental rights? See, one thing is we call it as fundamental because these rights, the rights which are in Part 3 of the Constitution, these rights are guaranteed by our Constitution. Fundamental rights are guaranteed by our Constitution, and as we know, our Constitution is fundamental law of the land. Because Constitution is the fundamental law of the land and the same Constitution guarantees rights, that is the reason why I call them as a fundamental right. That is one view, one approach. The other being, we also call these as fundamental rights because these rights enshrined in the Constitution will enhance or will help each individual or every citizen of the nation to develop their overall personality, be it material, be it intellectual, spiritual and all. There will cater us to develop an individual and give us an overall development. That is also one of the reasons why we call them as fundamental. ఈ ఫండమెంటల్ రైట్స్ ప్రాథమిక హక్కులు ఒక మనిషికి ఒక ఓవరాల్ డెవలప్మెంట్ని ఇస్తుంది. సో దట్ ఈస్ ద రీజన్ వై కాల్ దెమ్ యాజ్ ఫండమెంటల్. ఆల్ సార్ట్స్ ఆఫ్ డెవలప్మెంట్, ఎడ్యుకేషనల్, ఇంటెలెక్చువల్ డెవలప్మెంట్, స్పిరిచువల్ డెవలప్మెంట్, ఎకనామిక్ డెవలప్మెంట్, అంటే మెటీరియలిస్టిక్ కూడా ఇవి మనకి చాలా హెల్ప్ఫుల్ అవుతుంది. సో ఫండమెంటల్ రైట్స్ ఆర్ mentioned in Part 3 of the Constitution. Important, Part 3 of the Constitution from Article 12 to 35. We have these rights mentioned in Part 3 of the Constitution from Articles 12 to 35. Initially, we had 7 fundamental rights. Initially, we had 7 fundamental rights, but one fundamental right, that is right to property, has been deleted from the Constitution. Now we have only 6 fundamental rights. So what is the basic of these fundamental rights? What had made our Constitution makers to enshrine, to keep these fundamental rights? Because every individual, as we are democratic country, every individual should have some rights for their existence, for their growth, for their development. And if an individual develops, he will contribute for the development of any nation or any country. So fundamental rights not only gives fundamental rights or a strength, a power to an individual, it would also contribute for the development of entire country. That is the reason why we call fundamental rights as Magna Carta of India. So what is Magna Carta? In British Constitution, we have a great charter. Magna Carta is a great charter. You may also find a question in any question paper like, what is Magna Carta of India? Options would be fundamental rights, directive principles, fundamental duties and preamble. So we have to select a correct answer. That is, Magna Carta is fundamental rights. Fundamental rights are the Magna Carta of the Constitution of India. Magna Carta means great charter. We have a charter. We have a charter where individuals were given some rights in British. So as we know, it is mentioned in Article 12 to 35, and we have inspired from Bill of Rights of United States of America. In America, we have Bill of Rights. It is also similar to fundamental rights what we have taken, but in fact we got inspired of taking fundamental rights and enshrining in our Constitution from Bill of Rights, United States of America. In America, as we know, they give more prominence, more importance to individual, their liberty, their freedom, and hence Bill of Rights are a testimony of United States of America's working, their governance, their democracy. And we have inspired of taking fundamental rights from United States of America. There would be also a direct question, what is the source of fundamental rights? So fundamental rights we have taken from United States of America. As we know, fundamental rights are justiciable. What is justiciable? If any policy of the government, if any law of the state encroaches or violates the fundamental rights of a common man or a citizen, that particular common man can go to Supreme Court to fight for his justice. ఏ ప్రాథమిక హక్కు అయినా ఉల్లంఘించబడితే, ఏ గవర్నమెంట్ చట్టంతో ఆ ప్రాథమిక హక్కు ఉల్లంఘించబడితే ఆ పర్టికులర్ పర్సన్ సుప్రీం కోర్ట్ని అప్రోచ్ అవ్వచ్చు. సుప్రీం కోర్ట్ will take this case in its original jurisdiction. Supreme Court has its original jurisdiction to make these fundamental rights practical. So if any particular person feels that his fundamental right has been violated, he could approach Supreme Court through Article 32. 32 gives power, Constitution gives power according to Article 32 that Supreme Court could issue writs ఇష్యూ చేస్తుంది మన ప్రాథమిక హక్కుల్ని కాపాడడానికి. సో ఆర్టికల్ 32 is very much important. It is called the base, the foundation of fundamental rights. So similarly, Article 32 is for Supreme Court and Article 226 regarding high courts. One can approve or approach high court also by Article 226. So whenever there is a violation of fundamental rights or whenever there is a law brought by state government or central government which affects fundamental rights, that particular person or aggrieved citizen can move Supreme Court or can move High Court according to these articles. So they are justiciable. Justiciable in sense you can go and fight for your fundamental rights against state or anybody which brings such a law that violates your fundamental rights. Unlike directive principles of state policy, when we come to our next classes, we would be discussing DPSP, fundamental duties. Fundamental rights are justiciable, not DPSP and not fundamental duties. So justiciable adds, power, adds strength to all these fundamental rights. Have we not have these justiciable thing, we could not ensure that fundamental rights would be protected. ఒక్కవేళ మనకి ఈ ప్రాథమిక హక్కు కాపాడుకునే చట్టం లేకుండా ఉండి ఉంటే, ఈ ఆర్టికల్ 32 కానీ ఆర్టికల్ 226 కానీ లేకుండా ఉండి ఉంటే మన ప్రాథమిక హక్కులకి గ్యారంటీ ఉండకపోయేది. We could not expect that our fundamental rights would be protected. That is the reason why, according to Article 32 and 226, it has been mandatory. It has been, under original jurisdiction of the Supreme Court. It is the duty of the Supreme Court to protect our fundamental rights, and that is mentioned in the Constitution. Such a beautiful article these 32 and 226 are. That is the reason why I call them as bedrock of the fundamental rights. So you might have understand what justiciable is. Justiciable is whenever there is a violation of fundamental rights, you could move Supreme Court and also High Court as well. And fundamental rights are comprehensive. Comprehensive means it is overall, it includes everything, right from right to equality, to right to education, to right to employment, what not. Fundamental rights gives us everything what an individual needed for his individual growth, which also contributes for the development of the nation. So it is very comprehensive. You could see everything in that. It's a power packed thing where individual could generally see everything in this, and it is very elaborate also. Elaborate in sense it is mentioned in a very detailed manner. So detailed manner, right from Article 14 to Article 35, every single right has been categorized. Now, as we have only 6 categories, one is deleted, that is right to property. Now we have only 6 fundamental rights. Under it, we have sub things. So Article 14 to, for example, Article 18, we have right to equality. From 19, we have right to freedom. So in that manner, it is very elaborate in nature and it is categorized so beautifully. Everything is included in that. That is the reason why we call it as a comprehensive. Comprehensive means it comprises everything and it is also very detailed in nature, very elaborately explained, very beautifully categorized. One needs to understand this. One has to study fundamental rights in a very comprehensive manner. That is the reason why fundamental rights are very important, both in terms of knowing constitution and in terms of examination also. So moving to our next slide. So what does it do? What fundamental rights do? This is a continuation part. So it upholds equality. Equality is a very important word. Equality is a major thing in fundamental rights because Article 14 itself talks about equality. Equality is also mentioned in preamble. In preamble, we have equality, we have justice, we have freedom, we have fraternity. So equality is one of the trinity in the Constitution. Equality because one, if we don't have equality, there is no equal development. There may be a very unbalanced growth that would affect the fabric or development of any country. We have dignity. Every person, every individual expects some sort of dignity, be it dignity in labor, be it dignity in livelihood, be it dignity in his own perception. So every individual expects dignity and state should treat every individual in a very dignified way. మనము ఎంత చేసినా మనకు ఆ డిగ్నిటీ అనేది చాలా ఇంపార్టెంట్. అది వర్క్లో కానివ్వండి, లైవ్లీహుడ్లో కానివ్వండి, ఎంప్లాయ్మెంట్లో కానివ్వండి, ఎక్కడైనా పబ్లిక్ ప్లేసెస్లో వీ ఎక్స్పెక్ట్ సమ్ సార్ట్ ఆఫ్ డిగ్నిటీ బికాజ్ హ్యూమన్ బీయింగ్స్ క్రేవ్ ఫర్ డిగ్నిటీ. డిగ్నిటీ ఎక్కడ ఉంటుందో అక్కడే ఒక డెవలప్మెంట్ ఉంటుంది, ఒక వాల్యూస్ ఉంటాయి, ఫెయిత్ ఉంటుంది. సో డిగ్నిటీ ఈజ్ ఆల్సో బీన్ ప్రొవైడెడ్ బై ఫండమెంటల్ రైట్స్. And unity, because our India, our nation is very diverse culturally, very diverse geographically, historical background. As we know, we have very centuries of history. So such a diverse country, being such a diverse country, there is something which is uniting us in that way that primarily we know India is one thing. Then we talk about other states, other languages, other culture and everything. For example, just take when we see IPL, we have many teams. Team for Delhi, team for Hyderabad, team for Bangalore. But ultimately everyone has a fans. But when India plays World Cup somewhere far away from our country, but everyone cheers for India. That is unity. No, when it comes to the matter, we are one. India is one. So fundamental rights also enhances unity. Every person should have a sense of patriotism in them. So in our diverse culture, unity is an important thing where we are all one. We are one nation. So fundamental right guarantees unity. And what is political democracy? See, democracy is a very big word, as we follow indirect form of democracy. We follow a representative form of democracy. Political democracy means even we have other sort of democracy, like we have social democracy, we have economic democracy, but fundamental right guarantees political democracy. It promotes the idea, it promotes the desire of political democracy. It gives everyone the right to participate in elections. It gives everyone to have an opportunity of employment. It gives us a profession. We can have a unions. We can assemble everywhere. We can do job in anywhere in India. So these aspects of fundamental rights promotes political democracy. Authoritarianism. See, when we are talking about democracy, democracy is opposite word of authoritarianism or despotic rule. What is authoritarian? Niyantrata palana. So, where we don't have fundamental rights, we may expect some sort of authoritarian rule or despotic rule where people's aspiration is not taken into consideration in framing the policies. So government could become more authoritative or more undemocratic, but thanks that we have fundamental rights and it is guaranteed by the constitution according to article 32 and according to article 26, we could expect despotic rule, no despotic rule, because here fundamental rights, we could fight for our rights. There is there is a Supreme Court who protects our fundamental rights. Constitution itself protects our fundamental rights. So it leaves no chance for any ruler to become despot. So despot is like single man. He don't listen to people. Despotic means he don't consider people's aspirations. He don't consider people's views or people's interest. Government may sometimes becomes against the people. వాళ్ళ పీపుల్ కోరికలు కన్నా భిన్నంగా గవర్నమెంట్ పని చేయొచ్చు కొన్ని సందర్భాల్లో. ఎప్పుడు మనకు ఫండమెంటల్ రైట్స్ ఒకవేళ గ్యారంటీడ్ ఉండకపోతే అప్పుడు. అండ్ అథారిటేరియన్ ఇస్ నియంతత్వం. సో వేర్ or single man rule or single party rule would generally spoil democracy. So to have a successful democracy, we should be against authoritarian, we should be against despotic rule. So these fundamental rights works against authoritarianism. It doesn't allow to become authoritarian. That is the beauty of fundamental rights, because we have given power, people have given rights to fight for their own ideas, their expressions are being motivated, their feelings are being considerated. So fundamental rights gives us a strength to give our feelings, to show our feelings. And liberties and freedom. So what are liberties? Liberties are like we can do anything what we wanted to do. We have that liberty. In Western countries, people love liberty. In India, as we are not much literated country, literated nation, so we have constraints. We have small constraints as our country could not afford to education for all. So that thing are many other factors which have curtailed liberties, but otherwise fundamental rights has given us right to freedom, right to expression, right to profess any religion. So liberties are also been enshrined in fundamental rights. So saying all these things, we could understand that how important fundamental rights are. So tyranny. Generally, we've seen authoritarianism, despotic rule. These things are much politically involved. Tyranny is more of executive, more of bureaucracy also. Because in tyranny, one could not expect the governance to be run according to the will and wish of the people. So bureaucracy or any political government could become more tyrant that it may be running against the will of the people. So here will of the people are the aspirations of the people may not be considered in the ruling of the government. So fundamental rights are against the tyranny. Tyranny is being curtailed by the fundamental right. Tyranny is being reduced and it will promote democracy. When we are not tyrant, we are the lovers of democracy. So we shouldn't be more tyrant. And in that way, fundamental rights help us to propagate democracy and to reduce this tyrant. And fundamental rights also acts against these arbitrary rules, arbitrary laws. What are arbitrary? ఆర్బిట్రరీ అంటే ఇష్టారాజ్యంగా ఏదైనా చట్టం తీసుకురావడము, దానికి సైంటిఫిక్ వ్యాలిడిటీ లేకపోవడము. సో వెన్ there are no fundamental rights, or when the fundamental rights are not guaranteed by the constitution, maybe the government may become so obsessive with the power that it could make any policy, it could bring any law unscientifically. So ఏ ఆలోచన లేకుండా ఏ బేస్ లేకుండా కొన్ని చట్టాలు తీసుకురావచ్చు, అది ప్రజలకు ఇష్టంగా వ్యతిరేకంగా ఉండవచ్చు. సో arbitrary laws can be curtailed only when fundamental rights are there and it is guaranteed by the constitution. So fundamental rights also acts as limitations. It limits the arbitrary law because any law should be based on a scientific principle, because constitution gives us the power to the parliament, power to the executive, and also power to the judiciary. Any law should be based on the constitution. There is a limit, we have a boundaries, we have a boundary created by the constitution. So every law or every government should function according to the constitution, according to the people's will, because constitution is what? It is the people's sovereign. We have adopted the constitution for ourselves. So ultimately people are the source of power. So constitution is a boundary where any law should be within it, and fundamental rights guarantees this. It limits the arbitrary power of any government or any law which is passed by the legislature. Here legislature, be it parliament or be it assembly in the states. Continuing with this, a government of laws and not men. So fundamental rights ensures that a government should be run according to the prescribed law. Here we also call it as rule of law. Rule of law. We have to follow the law. Any policy should be according to the law. No man should be above law. So everyone are equal, everyone should follow certain law, and fundamental rights guarantees us that if any government policy brings a law which is against the fundamental principle of land, the Supreme Court will make it void. The Supreme Court will curtail it, because it is not by man, it is by laws. We have to follow laws. ఒక మనిషి కాదు, ఒక చట్టం అనేది ఇంపార్టెంట్ ఇక్కడ. సో గవర్నమెంట్ లాస్ కూడా ఒక సైంటిఫిక్ బేస్ మీద ఒక కాన్స్టిట్యూషన్ ఇచ్చిన పవర్లోనే పనిచేయాలి. And these fundamental rights are protected by the constitution. As I said, article 32, you please remember this, article 32 by Supreme Court has power, and article 226, High Court has power to issue writs. Writs are some tools to protect our fundamental rights. I'll explain this in coming classes. We have 5 types of writs: habeas corpus, mandamus, certiorari, prohibition, injunction. So we have these writs by which Supreme Court will issue writs to protect our fundamental rights. So fundamental rights are guaranteed by the constitution, and these are essential for all round development in sense, maybe economic development, maybe social development, maybe spiritual, maybe moral. So a person needs all these dimensions to make himself grow, make himself develop. So fundamental right gives us all round development, which ultimately adds for the development of the nation. Simple thing, if a person develops, a society develops, a family develops, then society, then state, and ultimately our country develops. That is the beauty of the fundamental rights. Okay, as we have discussed what fundamental rights are, how important they are for the overall development of any individual and obviously for the nation. So these fundamental rights are enshrined in Part 3 of the Constitution. Enshrined in Part 3 of the Constitution under Article 12 to 35. Very important part, and we need to know concepts of fundamental rights. We need to know what each and every article under fundamental rights, because they are very important in the exam point of view. అది చాలా ఇంపార్టెంట్. ఎనీ ఎగ్జామ్ కానివ్వండి, మనకి మేజర్ క్వశ్చన్స్ ఫండమెంటల్ రైట్స్ నుంచి వస్తాయి. అలాగే ఫండమెంటల్ రైట్స్లో క్వశ్చన్స్ చాలా కన్ఫ్యూషన్గా కూడా ఉంటాయి, బికాజ్ దే ఆర్ మెనీ ఆర్టికల్స్, అండ్ we need to remember those articles. We have to compare one article with other. No, we have 6 categorized fundamental rights, and we need to almost remember those fundamental rights. Here when we say features of fundamental rights, what are the characteristics of fundamental rights? So availability, to whom these fundamental rights are available. So fundamental rights, why we have this availability? Because fundamental rights are not uniform for everyone. We know some fundamental rights are meant only for citizens of India, and few fundamental rights are meant for both citizens and foreigners. We exclude enemy countries when we say foreigners. So few fundamental rights are available to only citizens. That is why we call them as availability. For example, right to equality, available to citizens. Right against offense, available to both citizens and foreigners. So these are things where few fundamental rights are available to only citizens, and few are available to both citizens and foreigners. Fundamental rights are not absolute. Not absolute in sense we have a limitation. We could say we have some limitations, and at some circumstances, in some time, we could impose limitations on fundamental rights. That is the reason why I say they are qualified, not absolute. For example, when emergency is imposed, then we have a limitations on fundamental rights. So that is the reason we say fundamental rights are not absolute, they are qualified. We should know that the government could impose reasonable restrictions on our fundamental rights, not in normal times, but at the time of emergency. For example, if there is a external aggression, if there is a war, when country is in the war, then the government or the parliament could restrict our fundamental rights, as happened in the time of emergency. That is the reason why we call fundamental rights are qualified. They are not absolute. The parliament can curtail fundamental rights, and you cannot move Supreme Court in such circumstances. We also say that fundamental rights are against arbitrary action of the state. What is arbitrary action? ఎప్పుడైతే స్టేట్ ఒక సైంటిఫిక్గా ఒక పద్ధతిగా ఏదైనా లా రాకుండా ఉంటే, ఇష్టానుసారంగా ఒక లా తీసుకొస్తే ఫండమెంటల్ రైట్స్ వాటిని అడ్డుకోవచ్చు. అకార్డింగ్ టు ఫండమెంటల్ రైట్స్, the court could curtail those actions of the states which have taken decision arbitrarily. ఒక ప్రజల ఇష్టానికి వ్యతిరేకంగా, if the state's action is against the interest of the people, then the court, the Supreme Court or High Court could make those law illegal or void if those laws are arbitrary in sense not well thought, not well approached. So it may be decided by some group which is against democratic values of the nation. So fundamental rights helps us, or it ensures that the state's action are not arbitrary. It will ensure that fundamental rights ensure that state should frame laws, or state should bring policies within the constitution, within the scope of the constitution, because ultimately constitution is the source of all the 3 branches. We derive power from the constitution. Parliament derive power from the constitution, and parliament should function according to the constitution. If any policy or if any law which is not within the limits of the constitution, it may be quashed by court, or it may be declared illegal, it may be declared void. So fundamental rights helps us to protect our fundamental things, our freedom, our liberty. That is the reason why we call these fundamental rights act against states' arbitrary action. Arbitrary action is a negative word. It is against democracy, is against people's interest. So had we don't fundamental rights, definitely we would be having a position where state would become more despotic, state would become more authoritarian. So fundamental rights ensures that the political party or any person should make laws within the ambit of the constitution. They should ensure that people's will should be protected. So these fundamental rights acts as a container in making more democratic, in making government function according to the democratic values. And we also say that fundamental rights are both negative as well positive. When we go into fundamental rights, right from Article 14 to Article 35, we would come to know that few fundamental rights restricts our movement, and few fundamental rights help us to grow, help us to progress. So both fundamental rights act as negative as well as positive. We would be dealing this when we see all those fundamental rights. What are the fundamental rights which acts as against negative? What are the fundamental rights which protects our values, which progress for the development of the people? So both we have negative as well as positive approach to fundamental rights. And fundamental rights are justifiable, they are justiciable, meaning we could move Supreme Court or High Court if any state's action violates the fundamental rights or violates the rights of a person. The Article 32 guarantees us to move Supreme Court, and it comes in original jurisdiction. So unlike DPSP, Directive Policy, Directive Principles of State Policy, and fundamental duties, both are not justiciable. These are justiciable. Fundamental rights are justiciable. They are guaranteed by the Constitution, and Supreme Court is protector of the Constitution. It has to make sure that the fundamental rights are protected. Every citizen have to make sure that he is not within the ambit of state's arbitrary action. If any law, if any policy of the government violates, a particular individual could go to Supreme Court and protect his rights. So justiciable is the bedrock, because fundamental rights are guaranteed by the Constitution, because they are called fundamental, because they guarantees the fundamental law of the land. They are justiciable, and that is the reason they are much important in the Constitution. So we also say that fundamental rights are not sacrosanct. Here not sacrosanct is, it is not permanent. పర్మనెంట్ కాదు. ఫండమెంటల్ రైట్స్ని మనము కొన్ని సందర్భాల్లో, కొన్ని ఎమర్జెన్సీ పీరియడ్లో దాని మీద లిమిటేషన్స్ పెట్టవచ్చు. అవి పర్మనెంట్ అని చెప్పలేము. సో దే ఆర్ నాట్ సాక్రసాంక్ట్. దే హ్యావ్ అడాప్టబుల్ ఇన్ నేచర్. దే కుడ్ బి curtailed in certain circumstances, right? For example, during emergency we can suspend fundamental rights. We have two exceptions, Article 20 and Article 21. So these two articles are not suspended, but otherwise all other fundamental rights can be suspended. For example, you cannot have right to freedom of movement, right to freedom of expression in times of emergency. Those fundamental rights could be curtailed by the parliament when we don't have a very peaceful environment. So these right against offense and right for life and liberty, these two are important articles which could not be suspended by the parliament. So except these two fundamental rights, all the fundamental rights could be at times suspended by the parliament. So what is Article 19? Article 19 is right to freedom. Right to freedom, generally what happens when we see external aggression or war? So definitely there are many chances, because already we have said that fundamental rights are not sacrosanct. They are not absolute. They are qualified. That is the reason why I say they are qualified, because at times Article 19 can also get suspended when external aggression is there, or when there is a environment of war. So fundamental rights scope is limited by Article 31 and 31B. We would be discussing these in details when we come to articles. So other features are, so when we say it has some limitations, it has some expressions or some exemptions, as we can say. Fundamental rights can be restricted to armed forces. We know armed forces, right from military, paramilitary, police. So these fundamental rights may not be applicable for them, because they are uniformed personnel. They have to work for the safety and they have to protect people, they have to maintain law and order. So they may not enjoy fundamental rights as a common citizen, because they are armed personnel, they are on borders, they work for the safety of the people. So for them these fundamental rights may not be applicable as applicable to a common man, as applicable to a common citizen. So Article 34, military rule. When there is a military rule or when there is a martial law in any state or in any area, then fundamental rights are not guaranteed in that area. Supreme Court or High Court may not intervene, because we have already mentioned that in our constitution. Now, by Article 34, when there is a military rule or where there is a martial law, we cannot guarantee fundamental rights as in normal times. So fundamental rights are self-executory. Many, not all, but many fundamental rights are self-executory, and other few fundamental rights need laws to make them function. So self-executory is, we have few fundamental rights in the constitution, for that there no law is required. Once it is mentioned in the constitution, it is self-executory. డైరెక్ట్గా అది ఎగ్జిక్యూట్ అవుతుంది. అలానే కొన్ని ఫండమెంటల్ రైట్స్కి ఒక చట్టం తీసుకురావాలి. అలా ఫండమెంటల్ రైట్స్లో రెండు రకాలు ఉంటాయి, కొన్ని సెల్ఫ్ ఎగ్జిక్యూటరీ ఉంటుంది, కొన్ని వాటికి చట్టం తీసుకురావాలి. సో వీ హ్యావ్ బోత్. We have few fundamental rights which can have a direct execution, that is self-executory, and few fundamental right needs basis of the law. Parliament should bring some law to make fundamental rights practicality, to bring them a practical nature. Parliament should bring some law that is mentioned in Article 35. So we also need to know what are the exceptions for the fundamental rights. It is not that fundamental rights is guaranteed to all the citizens. ప్రతి పౌరుడికి ప్రాథమిక హక్కులు గ్యారంటీ అని లేదు, కొన్ని ఎక్సెప్షన్స్ కూడా ఉంటాయి. ఫర్ ఎగ్జాంపుల్ పోలీస్ కానివ్వండి, మిలిటరీ కానివ్వండి, పారామిలిటరీ ఫోర్సెస్ కానివ్వండి, లేదంటే వేరే ఇతర యూనిఫామ్ ఇంటెలిజెన్స్ కానివ్వండి, రా కానివ్వండి. సో వాళ్ళకి ఫండమెంటల్ రైట్స్ వర్తించవు కొన్ని సర్కమ్స్టాన్సెస్లో, బికాస్ దే ఆర్ సంథింగ్ ఎల్స్. They don't function as a common man, because they have to work something else, somewhere else. They will be protecting our borders, they would be protecting our intelligence. So for them we cannot guarantee fundamental rights as generally we guarantee to our common people. So there are few exceptions where fundamental rights are not given to few personnel. Moving on. Now this is where we have seen what fundamental rights are, introduction to fundamental rights. We've also seen some features of fundamental rights. Now we would be dealing with fundamental rights in detail. So Article 12, very important article, where we have a definition of state. See, when we say fundamental right, that is for people, for a common man, ప్రాథమిక హక్కులు, అది ఒక ప్రతి మనిషికి కావాల్సిన we have that fundamental right which ensures that there is a development, there is a growth. బట్ అది ఎవరు తీసుకొస్తారు? ఫండమెంటల్ రైట్ ఒక కాన్స్టిట్యూషన్ మనకి ఇచ్చింది. అయితే స్టేట్ అనేది ఏంటి? వాట్ ఈస్ స్టేట్? స్టేట్ అంటే ఇక్కడ స్టేట్ గవర్నమెంట్ కావచ్చు, సెంట్రల్ గవర్నమెంట్ కావచ్చు, ఎనీ లోకల్ బాడీ కావచ్చు, అది ఒక డెఫినేషన్. సో ఏదైతే ఒక లా తీసుకువస్తుందో ఆ లా ఒకవేళ మన ప్రాథమిక హక్కుల్ని వైలేట్ చేస్తుందో అప్పుడు మనం సుప్రీంకోర్టుకి కానీ హైకోర్టుకి కానీ అప్రోచ్ అవ్వచ్చు. సో యాక్చువల్లీ స్టేట్ అంటే ఏంటి? So we need to understand what is state. For that matter, Article 12 has given a detailed definition of the word state. So generally we say when state brings a law which is against the fundamental rights, then court could intervene or a citizen could move the court to protect that fundamental right. So here we need to know what state is. State means here government. It may be central government or it may be state government. For example, central government, we know parliament passes the law. Parliament is the apex body which is the ultimate authority to make law, to frame law for India, for entire territory of India. It is the parliament consisting of two houses, both Lok Sabha, Rajya Sabha and president. Without president, we cannot pass any law. Ultimately, president has to sign on that bill to make it a law. So in parliament, we have three components: Lok Sabha, actually it should be president, Lok Sabha and Rajya Sabha. So parliament has three components. So parliament will bring laws which is affected in entire country, that is the jurisdiction is entire India. And we also has a government at legislature level, that is states. We know every state has its own assembly, we call it as assembly, and in union we call it as parliament. Legislature is a common word. So in state government also state is defined. Here in state we know it's parliament at union level, it's assembly at the state level, and in three-tier system, as we know, we have municipalities, we have panchayat raj according to article 243. We have local authorities. Even state is also defined, a local authority which also holds some power, like we know Zilla Council, it is also have some power to pass few bills which could affect that particular mandal or particular district. So even that authority is included in the word state. Here the word state is defined so elaborately that all the authority which is actually have power to pass laws which could affect the life of the people, that is defined as a state. Any authority or any body, be it statutory body or non-statutory body, for example companies, for example any thing which is associated fully or partly by the government has some authority to pass the laws. Like we have board, for example electricity board, it could also bring some laws to just hike the electricity bill. If that electricity bill or the tariff of electricity could affect the normal rights of the people, then any common citizen could move the court. That is what the state is. State is included all those central government, state government, local government, and all statutory and non-statutory authorities. So state is well defined in Article 12. We need to understand the definition of state, because we may expect a question here. State according to Article 12, central government, state government, local authority, none of the above, or we could miss something. So we need to know that all these four things comes under the definition of state: parliament, assembly, local authorities, and statutory and non-statutory authorities or bodies. So once we know what state is, we could move on. So here when we say applicability, of the fundamental rights, we have to know that fundamental rights, few fundamental rights are for only citizen of India. They are applicable to only citizen of India, and few fundamental rights are applicable to both citizens of India and the foreigners also. So we have to make a distinguish. We have to know what fundamental rights are applicable to only citizen of India and what are those rights which also applicable to foreigners. Here when we say foreigners, we exclude enemy countries. Enemy countries are not treated as foreigners. So what are the fundamental rights which are guaranteed to only citizens of India? So what is Article 15? This we will be going into detail. Like for example, Article 15 is Prohibition of Discrimination. Prohibition of discrimination only on the grounds of religion, region, caste, sex and place of birth. So 15 article, the components in Article 15 are only applicable to the citizen of India. So prohibition of discrimination against these things. So we can also say that for foreigners we are not applying this article. We can have discrimination when it comes to foreigners, but for citizens we cannot discriminate only on the grounds. We have to see this only when we discuss these details. There is a very valuable word, only. Only. Prohibition of discrimination only on the grounds of religion, race, caste, sex and place of birth. So all these 5 things only. So only state. So only state could prohibit. So discrimination on these 5 things. That is Article 15, only applicable for the citizens and not for the foreigners. When we say Article 16, it's providing employment. Providing employment. The state should provide employment to everyone, to the needies. So this provision of employment is only applicable for citizens of India. They are not applicable for the foreigners. So Article 19, right to freedom. We have right to freedom of expression, right to freedom of speech, right to freedom of assembly, right to freedom of association, right to movement and right to settle anywhere in India. We have these 5 components in Article 19 which is guaranteed only for citizens. They are not guaranteed for foreigners. So we have to know what are the articles which are given exclusively for citizens of India. Article 29, Article 30, these have, we have a freedom to protect our culture, freedom to protect our culture and for language, scripts for minorities and all. So this is also guaranteed only for the citizens and not for the foreigners. So we have to just understand, just remember in a logical way. Article 15, 16, 19, 29 and 30 are guaranteed only for the citizens. It's a very important point in view of examinations. There may be some confusing questions in that. Generally when we also know what are the fundamental rights which are guaranteed for both citizens and foreigners, we would be clear. We would be clear in remembering these. Moving on to the next topic. See, it's a very detailed thing. What are the fundamental rights which are guaranteed for both citizens of India and also for the foreigners, foreign nationals. So these are the fundamental rights. Many elaborate. See, Article 14, right to equality. 20, right against offense, right for life and liberty. This Article 21A, very newly given article, right for elementary education, right against arrest and detention. Article 22, foreigners, foreigners cannot be arbitrarily arrested. They cannot be detained. They have the fundamental right. Any foreigner who landed in this country, makes any thing which is against the law, they cannot be arbitrarily detained by the police or by any such enforcement agency. So even foreigners have the life. They have right against offense, right against life, right for life and liberty. Article 21, they can also enjoy this Article 21A, that is right for elementary education, free education. Article 22, right against detention. So these are the things, many things, like when we say Article 23 and 24, they are also very important. Generally, these articles gives us right against human trafficking, right against labor, forced labor. So ilanti rights kuda foreigners ki kuda vartistai. So we have Article 25, 26, 27, 28. This is right for religion. Religion ki sambandhinchi ఈ రైట్స్ ఉన్నాయి. Foreigners could also enjoy these rights. So our constitution has very elaborately given few rights which are applicable only for citizens of India and many rights which are applicable to both citizens and foreigners. And when we discuss each article in detail, we would be knowing very much about these articles. I've just given a small introduction about these, but we have to know each and every article in detail. We need to also be comparing each article one by one. So this is just we are knowing what are the basic features of the Constitution. So we are just briefly knowing this. So when we say applicability, we say few are applicable to citizens and few are applicable to foreigners. So now we would be going into detail in our fundamental rights chapter, which is under part 3. Again, I am repeating, fundamental rights are mentioned in part 3 of the Constitution. Important part 3, where we have fundamental rights. Part 4, we have directive principles of state policy. Part 4A, fundamental duties. These 3 parts are very much important, and we know that fundamental duties were not part of our original Constitution. They have been amended, they have been added. So part 4 also have part 4A. Under article 51A, we have fundamental duties. So in coming classes, we would be doing those fundamental duties, DPSP, and fundamental rights also. Very important topic in Indian polity, where we could expect many questions from these. And obviously the questions are so close that without conceptual clarity, we would be landing in a wrong answer. So first, we'll know what right to equality is. Right to equality guaranteed by Article 14. So we have 2 provisions in right to equality. We have equality before law. Equality before law and equal protections of the law. There is much difference and obviously much confused chapter. We have to know this. What is equality before law? Equality before law, we have taken this from UK. And equal protection of laws, or equal protection by laws also, can be said that this we have taken from United States of America. So we need to understand in detail what is equality before law and what is equal protection of law. So Article 14 guarantees us equality, right to equality. In that we have equality before law. So what is equality before law? Equality ante ప్రతి మనిషి చట్టం ముందు సమానం. అందరూ చట్టానికి సమానులే. ఎవరు పెద్దలు కాదు, ఎవరు చిన్నవాళ్ళు కాదు. సో ఇక్కడ నో స్పెషల్ ప్రివిలేజెస్ గివెన్ టు ఎనీ సింగిల్ పర్సన్. ఒక వ్యక్తికి కానీ ఒక సంస్థకి కానీ ఒక ప్రయారిటీ అనేది ఇవ్వరు. లా అందరికీ సమానము. లా ముందు అందరూ సమానులే. సో ఈక్వాలిటీ బిఫోర్ లా ఈజ్ నో స్పెషల్ ప్రివిలేజెస్ ఆర్ నో స్పెషల్ ప్రొటెక్షన్ గివెన్ టు దోస్ పర్సన్స్ ఆర్ those individuals. So when we say equality before law, we say that there is nothing special to anyone. Maybe he's rich, maybe he's poor, special privileges are not given. Everyone is equal before the law. Another provision in this is equal subjection of laws. When I say equal subjection of laws, every law of the land, we know Constitution is the highest law of the land, and we derive every power from the Constitution. All the 3 branches of the government, be it Parliament, be it executive, or be it judiciary, all these 3 branches derives their power from the Parliament. So Parliament is like law making body, and when a Parliament brings law, or when judicial gives a judgment, that judgment is applicable to all persons. Every person has subjugation under the law. So we are a subject of law. Law is for everyone, equal for everyone. So equal subjection of laws on all the people. That is one thing. And when we say no person is above law, here we say no special privileges. Here we say no person is above law. ఒక మనిషికి స్పెషల్ ప్రివిలేజెస్ అనేది ఉండదు. చట్టం ముందు అందరూ సమానులే. ఇక్కడ ఏ మనిషి చట్టం కన్నా పెద్దది కాదు. ఎవ్రీ పర్సన్ ఈజ్ below the law. So here law is ultimate, and every person, irrespective of his stature, class, region, religion, every person is below the law. That is where we call it as rule of law. We follow rule of law. Rule of law is such a beautiful word given by A.V. Dicey. So here no person is above law. That is where we could maintain equality. చట్టం ముందు అందరూ సమానులే. సో ఒక వ్యక్తి కానీ ఒక వ్యవస్థ కానీ చట్టానికి పైన ఉండదు. చట్టం అనేది అందరికీ సమానంగా ఉంటుంది. వ్యక్తి ముందు కాదు, చట్టం ముందు. లా ఈజ్ అబౌవ్ and person is below. So every person should be subjugated under the law. Equal subjection. Prati manishi, irrespective of his position, posture, everyone is under the law. So this is what right to equality is. You just imagine if there is no right to equality, what had happened? No, there might be a chaos. ఒక టైప్ ఆఫ్ కన్ఫ్లిక్ట్ వచ్చేది. ఈ సమానత్వం లేకుంటే ఎవరి దగ్గర అయితే ఎక్కువ డబ్బులు ఉన్నాయో వాళ్ళు చట్టాన్ని కొనుక్కునేవాళ్ళు. సో పీపుల్ హూ హ్యాడ్ మోర్ అసెట్స్ వుడ్ డెఫినెట్లీ వైలేటెడ్ ద లాస్. సో దట్ ఈస్ ద రీజన్ వై హ్యావ్ ఈక్వాలిటీ. ఈక్వాలిటీ గివ్స్ అస్ అ సెన్స్ ఆఫ్ జస్టిస్, బీ ఇట్ సోషల్ జస్టిస్, political justice, economic justice. Equality ensures us to work, to come out and work. So equality gives us a sense of protection. That is why we call fundamental rights are such an important part of the Constitution, which motivates us, which guarantees us to bring more special things from us and to contribute for the development of the nation. So this is what equality before law is. Other aspect of right to equality we need not to confuse here is just a small difference. As we say equality, right to equality, we have brought that equality before law is brought from United Kingdoms, and here right to equality, equal protection law, this we have brought from United States of America. So very nominal difference here. So what is equal protection of law? Equal protection of law. So equality of treatment under equal circumstances. Equal circumstances అంటే ఒక సమాన పరిస్థితిలో అందరినీ సమానంగా చూడాలి. పరిస్థితులు వేరేగా కావచ్చు. When we say equal protection of law, this is a positive concept of equality, and that provision was a negative concept. Here మనం ఏం చెప్తున్నామంటే equality of treatment under ఈక్వల్ సర్కమ్స్టాన్సెస్. ఇక్కడ అందరూ సమానులే అని మనము జనరల్గా చెప్పలేము. బికాజ్ we know a healthy man and a old woman may not be equal, or a child and a man cannot be equal. వాళ్ళిద్దరికి ఒక వ్యత్యాసం ఉంటుంది. there is a difference. సో మనం జనరల్గా చూస్తుంటాము ఆర్టీసీ బస్సెస్ కానివ్వండి, ట్రైన్ కానివ్వండి, we have reserved some seats for elder people, for women. So it is like we are exception, we have some exceptions. ఇక్కడ ఏంటంటే ఈక్వాలిటీ ట్రీట్మెంట్ ఉండాలి, ఎక్కడ ఈక్వల్ సర్కమ్స్టాన్సెస్ ఉన్నప్పుడే ఉండాలి. అదర్వైజ్ వీ కెనాట్ జస్ట్ సే దట్ అ ఓల్డ్ లేడీ ఈజ్ ఈక్వల్ టు అ యంగ్ మ్యాన్. So there has to be some difference, no? So we have to treat that equality of treatment in equal circumstances. పరిస్థితులు సమానంగా ఉన్నప్పుడే ఆ సమానత్వం అనేది మనం చూస్తాము. So that is one aspect of this. And we say similar application of laws. ఒక మనిషికి ఫర్ ఎగ్జాంపుల్ ఒక క్రైమ్ చేస్తే ఇంకో మనిషికి ఆ క్రైమ్ చేస్తే ఆ లాస్ అనేది ఇద్దరికి ఈక్వల్గా అప్లికబుల్ అవ్వాలి. సో వన్ లా షుడ్ బి ఈక్వల్లీ, సిమిలర్ వైలేషన్కి సిమిలర్ లా అప్లికబుల్ కావాలి. సో సిమిలర్ అప్లికేషన్ ఆఫ్ లాస్. అండ్ లైక్స్ షుడ్ బి ట్రీటెడ్ అలైక్. లైక్స్ అంటే ఫర్ ఎగ్జాంపుల్ సమానంగా ఉన్నవాళ్ళు, ఫర్ ఎగ్జాంపుల్ గ్రూప్ ఆఫ్ యంగ్ మ్యాన్, దే హ్యావ్ టు ట్రీటెడ్ అలైక్. అందరూ సమానంలే. ఫర్ ఎగ్జాంపుల్ వీ కెన్ సే ఇన్ ఫ్యూ కాలేజెస్ వీ హ్యావ్ both girls and boys, there is a co-education. So there definitely we cannot apply that particular law for them, because there is some difference in them, be it physical difference, be it mental. So we cannot say that everyone should be cross this level. Long jumping anukundamu, high jumping lo okati లెవెల్ ఇచ్చేసి అందరూ దాన్ని జంప్ చేయాలి అని సమానంగా పెట్టలేము మనం. దేర్ ఈజ్ నాట్ ఈక్వాలిటీ దేర్ బికాజ్ వీ హ్యావ్ జెండర్ డిఫరెన్సెస్. సో లైక్స్ షుడ్ బి ట్రీటెడ్ అలైక్. లైక్స్ మాత్రమే అలైక్గా చూడాలి. ఎవ్రీవన్ ఈజ్ నాట్ సింగిల్, everyone is not alike. So there may be an exception in this. That is where like we have reservation system for ST, SC, OBC minority. There is some privileges given to them because everyone are not alike, be it economically and be it socially. So there are some things where we cannot say that equality is absolute. Everyone should be equal. There are things likes should be treated alike, and there may be government may involve and give some provisions where there is an interest to bring them or to uplift them. So we have few exceptions for that. That is what we say that equal protection of law. In equality, in right to equality, as we said, we have two dimensions. One is equality before law and equal protection of law. We will be continuing with fundamental rights. As we know, fundamental rights are enshrined in Part 3 of the Constitution from Article 12 to 35. These are very important rights which are fundamental for the development of every individual. Why we call these as fundamental rights? As we've discussed already, these are fundamental rights because they are guaranteed by the Supreme Court. They are guaranteed by the Constitution of India. And the Constitution of India is the fundamental law of the land. That is the reason why we call these rights as fundamental rights. And fundamental rights are justifiable in the court. That means if any right is violated, the aggrieved person can move Supreme Court under Article 32, and under Article 26 they can go to high courts. So this is the beginning of fundamental rights, and we would be discussing today in our class Article 15. So we have from Article 14 to Article 18, it's broadly described as right to equality. So here we have Article 15. Now what is Article 15 in our Constitution? Article 15 prohibits discrimination. That is, Article 15 prohibits discrimination only on the grounds of religion, race, caste, sex and place of birth. So here Article 15 prohibits discrimination. What is prohibition? Prohibition of discrimination. Discrimination is when you separate someone or when you distinguish someone unfavorably. ఒక వ్యత్యాస చూయించడం, ఒక మనిషిని ఒక సపరేట్గా చూడడం అనేది డిస్క్రిమినేషన్ అంటారు. ఒక లాంటి వివక్ష చూయించడం. సో డిస్క్రిమినేషన్ ఈజ్ ప్రొహిబిటెడ్ బై Article 15 on the grounds of religion, race, caste, sex and place of birth. Only here we use only on these 5 bases. So Article 15 prohibits discrimination on certain grounds. We have to know what are these certain grounds and what is discrimination. So this discrimination is basically for social equality. We are providing everyone, regardless of their religion, their caste, their gender, their descent or their place of birth. The state is giving everyone equal opportunity to progress. And that is the reason this article enhances or it gives social equality, and it also gives us equal access to public area. Public area here is anything which is funded by government, let us say park, tank, well, public restaurants, or any places where every person has equal access. So here Article 15 discriminates, or we have a distinction where it is prohibited that any state law or any individual could not distinguish, or any state law should not distinguish a person on the basis of his religion. We say certain grounds. We would be discussing this on our next slide. So here the two important things are Article 15 empowers to have a social equality in the society, and it also gives everyone equal access to public area. So what are this public area, and how this Article 15 improves or it provides a basic for equality? When we say social equality, what are the basis for discrimination? What are the basis for discrimination? We have to know basis for discrimination is religion. One of the basis for discrimination is religion. Only is very important word here, because the state cannot discriminate a person only on these 5 things. So what is religion? We are heterogeneous society. We have multi religions. We have Hinduism, we have Muslim, Christianity, Sikh, Jainism and all. So a state should not discriminate a person on the basis of religion. And as we know, there is a racial system. We are wondered that in Western countries, even today, the state has many problems regarding this racial. People are being discriminated on the basis of racial. Fortunately, we haven't seen this in our India. We have very few instances, and no instance that the people have asked the Supreme Court on the basis of racial discrimination. And because we have multi-caste system, we have caste system, so on the basis of caste also, the government should not discriminate any person. We can also say that the state shall not discriminate any person on the basis of gender. Gender discrimination is also prohibited. Gender in sense sex, male, female. So this is also discriminated, or a state shall not discriminate a person on these basis. And we have place of birth. As we know, we have single constitution, we have single citizenship. So the state cannot prohibit or cannot discriminate a person only on the basis of place of birth or his descent. So we have few exceptions for this. We have few exceptions. When we say only, we have only 5 bases, as we have already talked about that. That is religion, race, caste, place of birth and sex, that is gender. On these 5 bases only, the government prohibits discrimination. That means on other bases, the government or the state can discriminate. We can discriminate. Other than these 5 things, the state can discriminate the people. That is a positive discrimination. That is providing a special provision for certain classes. For example, we have women, we have children. When we provide some seats in train or bus reserved for women, that doesn't come under this discrimination. So children can be discriminated in certain things. Children cannot be given an employment in a factory where there is a danger to his life or to her life. So the things we have discrimination is only on these 5 bases. Other than this, state can discriminate, and that is where we call it as a positive discrimination. So we have equal access to public area. The before one when we say no person is discriminated on some basis, it is applicable to the state, and this is applicable to both private and state, that is government. So here when we say right to equality and when we say prohibition of discrimination under Article 15, we say prohibition of discrimination, that is giving equal access to public area. Public area is maybe shops, any shops, restaurants, malls, we have equal access. No person or no citizen should be discriminated on any basis. That is, everyone is eligible to enter the shop, to purchase, to have shopping. So no one could stop a person by entering the shops. So everyone has equal access to the shops, that is public area or public places. We have public restaurants. So anyone can enter any restaurant irrespective of their religion, caste and such things. So everyone has an equal opportunity or equal access to enter the restaurant and to enjoy their food. Hotels, public entertainment places like theaters, or any other areas like parks, amusement parks, people can enter anywhere. So they have equal access to all those public places. Like we also have wells, we also have tanks or any bathing ghats. Earlier there was very strict orthodox society where people were prohibited to enter certain areas because of their caste, because of their lower caste. They've been humiliated. So because we have such a culture, our constitution has made it clear that no person be prohibited to areas of public usage. Anyone can enter. We have those orthodox things which have been removed in our constitution. Our constitution have gave equal power to everyone to have access to all those public areas without any restrictions. So this is a right to equality. We have a few exemptions for this. We have few exemptions. When we say discrimination, we also have protective discrimination. We have protective discrimination where we can protect women, we can protect child, we can protect our elderly people. So discrimination, the state can go for discrimination in certain areas where the state needs to protect certain sections of the people. Certain sections of the people, maybe they are vulnerable sections, maybe scheduled caste sections, scheduled tribe people, or economically backward society. So here the government can take steps or make special provisions for their advancement in the society, for their overall development. Because when we say right to equality, here we cannot expect everyone to grow at same pace or same level. Few peoples are elite, few are privileged, and few are not privileged, few are underprivileged. So it is the duty of the state that to make this equality a reality, the government should take, or the state should take certain steps to make equal access or to provide a platform where the vulnerable section or where the underprivileged section have an opportunity to compete with the privileged section. Otherwise, we would not expect equality. We cannot make equality as a reality. So until and unless the state doesn't provide a special provisions for economically weaker section or for educationally weaker section, there is no equality. We have to make equality only when the state is proactive in making lives better of poor, vulnerable and underprivileged sections of the society. So this is mentioned in Article 15 clause 4. What it says? Promoting the interest and welfare of socially and educationally backward classes of the society. So we have certain sections of the society, for example, backward classes. We have scheduled caste, scheduled tribe and other backward classes of the society, which they could not compete with the privileged section. So the state will interfere, the state will intervene, and it promotes the interest and welfare of those people by bringing certain special provisions. By bringing certain special provisions, it will promote the interest of the people. For example, 93rd Amendment Act 2005 says that it has given reservation of 27% in higher educational institutions. Higher educational institutions like IIMs, like IITs and many central universities in admission. So students could avail this. Students could avail this, getting admitted into these higher educational institutions like various central universities and very prestigious institutions like. Otherwise, they could not compete with the privileged sections of the society. Here we are making this provision for bringing equality, because we are talking about Article 15 and it is mentioned in preamble. It is the basic structure of our constitution that the state has to strive to bring equality in the society. So these many amendments have given access to various sections of the people to education, for government jobs and all. So the state is striving continuously to bring a sense of equality, to bring an equality in the society, so that the fruits of development would reach everyone. So we also have a case in this. Article 15 clause 5, reservations about admissions into educational institutions. As we've already said, we have given 27% reservation for OBC category. In the same way, we also have reservations for scheduled caste, scheduled tribe, and recently we also had EWS, economically weaker sections of higher caste. This reservation is based on their economical conditions. If the person or if the individual from higher caste is very poor, then the government has given 10% quota for them also to avail these benefits, to bring equality in the society. 15 of clause 3, entire article 15 talks about equality. Equality, that is, we are prohibiting discrimination. We are prohibiting discrimination. So these are few exceptions. These are few exceptions where government will interfere or intervene by promoting or by bringing certain special provisions which helps the underprivileged section of the society to compete with the already haves or privileged sections of the society. So here reservations are exceptions to Article 15. So what is Article 16 here? Article 16 is equal opportunity in public employment. So bringing equal opportunity in public employment. Public employment is jobs under government or funded by the state. So here also we have few things to understand. Here also when we say right to equality, there are many exceptions to this. Everyone are equal or eligible to get into the government jobs irrespective of their religion, region, caste, gender or place of birth. So everyone are equally eligible, but again we have certain exceptions here. The state could have no discretion to allow certain persons or to make certain quota for local people, or it will decide on how much of the quota is given for non-locals. So the government or the state has discretion. The reservation to class who are not adequately represented. So the government could reserve certain seats or certain post in government sector where it could be reserved to certain sections of the people like scheduled caste, scheduled tribes, women, minority, etc. Where we know that in government offices certain posts are reserved, so they are filled by those people who are not adequately represented in the government sector. So government has an opportunity, government should take an opportunity to ensure that everyone is equally represented in state governments, or be it state government, be it parliament, or anywhere in any public offices. When we say equal opportunity in public employment, the state has to take responsibility that every section of the society should be represented in public office according to their population at least. So the reservation to class who are not adequately represented in the services should be given. So the reservation is the few seats should be reserved for them who are not adequately represented. This is to bring equality again. This is to bring the people who are not represented in the society. That is to bring those who are not adequately represented to participate in a decision making, to participate in the governance, to participate in the functioning of the country. Here another thing is, those who are not unequal cannot be treated by identical standard. Those who are not unequal cannot be treated by identical standards. See, when we say equals should be treated alike, you cannot treat a person, rich person to poor people. Those both cannot be treated equally. So in the same way, a higher educated person and a person with a nominal education cannot be treated equally. In the same way, a strong person cannot be treated equally with a weak person. That is why the state has to take an opportunity to create a platform where likes are treated alike. Otherwise, the underprivileged, the weaker sections of the society should be given some sort of upliftment, so that the society, in society, he could compete with the current competition. In that same way, the reservation in educational institutions, reservation in public employment, or providing scholarships to the students, these things will enhance the lower category people or people from economically weaker sections to compete with the people of that level. So we would be saying that Article 16 takes an opportunity of equality in public employment. So we were discussing about right to equality under Article 16. We have few exceptions for right to equality under Article 16. When we say that there should be equal opportunity in public employment for everyone, we have certain exemptions. See, any state or any place, any residence or any state will not provide with employment for everyone. So here Parliament can prescribe certain norms, certain residential norms as a condition for the employment. For example, we have in Telangana, mana AP lo, Telangana lo, Parliament అనేది స్పెషల్ ఒక లా పాస్ చేసి ఇవ్వబడింది అండర్ ఆర్టికల్ 371D. ఇది ఓన్లీ మన తెలుగు రాష్ట్రాలకే చెందింది. 371D ప్రకారం మనకి ఒక లోకల్ రెసిడెన్షియల్ అనేది ఒక కండిషన్ ఉంది. సో మన పబ్లిక్ ఎంప్లాయ్మెంట్లో ఎగ్జామ్ రాస్తున్నప్పుడు తెలుగు సబ్జెక్ట్ అనేది కంపల్సరీ పెట్టారు. ఇతర రాష్ట్రాల వాళ్ళు తెలుగులో వచ్చి తెలుగు ఎగ్జామ్ రాయలేకపోతారు. సో we have certain conditions, we have certain local conditions which is decided by the Parliament. So Parliament could make certain laws to decide on residence as a condition for certain employment. The state can also provide certain reservation for backward classes. We have seen where the state can provide reservation in employment certain in backward classes. So reservation is a subject where many of the people would compete. So reservation is provided for the equal benefit of all the sections of the people. And here one more exception what we have is a law to appoint religious incumbent. ఎప్పుడైతే మనము రైట్ టు ఈక్వాలిటీలో ఈక్వల్ ఆపర్చునిటీ ఇన్ పబ్లిక్ ఎంప్లాయ్మెంట్ అంటామో అక్కడ కొన్ని ఎక్సెప్షన్స్ ఉన్నాయి. అక్కడే అపాయింట్మెంట్ ఆఫ్ రిలీజియస్ ఇన్కంబెంట్స్. సో కొన్ని రిలీజియస్ పోస్టులు ఉంటాయి, వాటిలో ఆ రిలీజియస్కి సంబంధించి పర్సన్ని మాత్రమే అపాయింట్ చేయగలుగుతుంది. సో అది ఈ యాక్ట్కి అగేన్స్ట్గా అని మనం సుప్రీంకోర్టుకి వెళ్ళలేము. we cannot move Supreme Court only on the basis that certain religious post is filled by only those people. So here we are not violating any law, we are not discriminating anyone, because we have certain exceptions. For example, a Hindu temple where they will appoint a person from Hindu category, a Muslim mosque they will appoint a person from the same religion, and same way a church will appoint a father from the same community. So there are certain exceptions. We cannot move Supreme Court that there is no equality, there is a violation of Article 16, because we have certain exemptions to these things. So Article 16 has many provisions in employment. So we have to know Mandal Commission. Mandal Commission has been instituted in 1979 when Morarji Desai government has formed. That Mandal Commission has been appointed to look into the matters of backward classes. A Mandal Commission is BP Mandal, who was a member of parliament. He has headed this commission. So Mandal Commission has been appointed in year 1979. He has submitted report in 1980. He has decided, he has given the recommendation that almost 3,700 plus castes are there which are socially and economically very backward. He said that all these people or all this section of the society represents nearly 52% of the population, of the total population. So Mandal Commission's recommendations given the report that almost 52% of the total population, excluding SCs and STs, almost 52% of the population are backward class. So he recommended that the government should take step so that they are equally represented in public office. So Mandal Commission's report has been submitted to the government. This Mandal Commission has been instituted, or the Mandal Commission has been established on the base of Article 340 mandates. It is mentioned in the Constitution లో ఆర్టికల్ 340 ఏం చెప్తుందంటే ఒక కమిషన్ని గవర్నమెంట్ ఏర్పాటు చేసుకోవచ్చు, ఒక బ్యాక్వర్డ్ కమిషన్ని గవర్నమెంట్ ఏర్పాటు చేసుకోవచ్చు. దానివల్ల ఎంతమంది ఎక్స్క్లూజన్ చేయాలో తెలుస్తుంది. సో ఈ మండల్ కమిషన్ యొక్క రిపోర్ట్ మీద ఆధారపడి మన గవర్నమెంట్ చాలా డిసిషన్స్ తీసుకుంది. ఇది 1979లో ఎస్టాబ్లిష్ చేసింది, 1980లో ఆ రిపోర్ట్ అందడం జరిగింది గవర్నమెంట్కి. 10 years తర్వాత, 10 సంవత్సరాల తర్వాత 1990లో VP Singh government, when VP Singh was the prime minister, he has provided 27% reservation for OBC. He has provided 27% reservation for OBC, so that these 27 reservation excluding SC and ST రిజర్వేషన్ కాకుండా 27 రిజర్వేషన్ ఇవ్వడం జరిగింది. అది మొత్తం 50% క్యాప్ని దాటకుండా చూసుకున్నారు. సో ద రిజర్వేషన్ గివెన్ టు OBC was 27%, which made sure that it didn't cross 50% of the limit set for the reservation. So VP Singh government has made sure that he has given 20% reservation for OBC section. Again in year 1991, Again in year 1991, when P.V. Narasimha Rao was the Prime Minister, he said that in this 27%, the people should be selected on the basis of economy. So that before this, before 1991, P.V. Narasimha Rao government has said that 27% for OBC was for everyone. So there was no economy as a standard, economical standard అనేది క్రైటీరియా లేదు. 27 రిజర్వేషన్ అందరూ ఓబీసీకి వర్తించింది. కానీ 1991లో పివి నరసింహారావు గవర్నమెంట్ ఆ 27%లో ఎకనామికల్లీ వీకర్ సెక్షన్స్కి ప్రయారిటీ ఇవ్వాలని ఒక క్రైటీరియా తెచ్చారు అనమాట. సో దిస్ హ్యాస్ ఫార్మ్డ్ ది బేసిస్ ఫర్ క్రీమీ లేయర్. ఒక క్రీమీ లేయర్ అనే కన్సెప్ట్ ఫామ్ ఇక్కడ అయింది. సో ఈ 27% రిజర్వేషన్ ఓన్లీ ఎకనామికల్లీ బ్యాక్వర్డ్ సెక్షన్కి ఇవ్వాలని నిర్ణయం చేసుకున్నారు. సో we had a new concept of creamy layer. Creamy layer అంటే ఆల్రెడీ పెద్ద ఉన్నత స్థాయిలో ఉన్న వాళ్ళు, ఎంపీస్, ఎమ్మెల్యేస్ కావచ్చు, సుప్రీంకోర్టు, హైకోర్టు జడ్జెస్ కావచ్చు, లేదంటే గవర్నమెంట్ ఆఫీసెస్లో గ్రూప్ 1, గ్రూప్ 2, సెంట్రల్ సర్వీసెస్లో ఉన్న ఆఫీసర్స్ కావచ్చు, వాళ్ళ పిల్లలు కానివ్వండి, వాళ్ళ ఫ్యామిలీ ఈ రిజర్వేషన్కి అనర్హులు అని చేశారు. సో క్రీమీ లేయర్ అనేది మనం డిఫైన్ చేయడం జరిగింది. ఎక్కడైతే ఒక కాన్స్టెంట్ ఇన్కమ్, యాన్యువల్ ఇన్కమ్ ఇంతకంటే ఎక్కువ ఉంటుందో, దే ఆర్ నాట్ eligible to avail reservation. So we have brought in a special thing like creamy layer which decides that only economically weaker section could take these benefits of the state already, which the people who have a privileged nature or who are already settled could not avail these reservations in government offices. After that, like we have Ram Nandan committee, we have National Commission for backward classes has been established. We also could say that few things like now what we say that economically weaker section of the society, in recently we have seen in 2019 the Modi government has passed this by 103rd Amendment Act, giving 10% reservation for economically weaker section of the society. So on the basis of their annual income, if the annual income is below 8 lakhs, they could be eligible for getting government post or opportunity under 10% reservation. So higher caste people also, if they are economically weaker, then they could avail this 10% reservation. That is the recent thing. And here when we say there is a reservation in appointment or employment, by this 77th Constitutional Amendment Act, we also have given reservation in promotions. Reservation also been provided in promotions for SC and STs. So 77th Constitutional Amendment Act has given and said that reservation are also applicable for promotions in government employment. So that was Article 16, which guarantees equality in public employment. We have few exceptions. మనకు ఎక్కడైతే ఎక్సెప్షన్స్ ఉంటాయో కాంపిటేటివ్ ఎగ్జామ్స్లో క్వశ్చన్స్ అక్కడి నుంచి ఎక్కువ వస్తాయి. సో వీ హ్యావ్ టు బి వెరీ కేర్ఫుల్ వాట్ ఆర్ ద ఎక్సెప్షన్స్. మనము ఈజీగా ఆర్టికల్ 16 అంటే పబ్లిక్ ఎంప్లాయ్మెంట్లో ఈక్వాలిటీ ఉంటుంది అని చెప్పేస్తాము, కానీ ఎక్సెప్షన్స్ చాలా ఉన్నాయి. రిజర్వేషన్ క్రైటీరియా తీసుకోండి, క్రీమీ లేయర్ క్రైటీరియా తీసుకోండి, రిజర్వేషన్ ఇన్ ఎంప్లాయ్మెంట్ అండ్ ప్రమోషన్ తీసుకోండి, మండల్ కమిషన్ అండ్ వేరియస్ things regarding to it adi తీసుకోండి. So we have many things where we have very confusion type of questions. So we have to make our concepts clear. Just not knowing what Article 16 is, we need also to understand the basics of Article 16, how it affected the future employment process. So we need to be very clear here, and we should be able to learn few facts, know few facts also, just not reading Article 16, we have to be very careful when we read sub-clauses. Article 16(1), Article subclause 2. So these are very important when it comes to examination and questions. Now moving on to other fundamental right under right to equality, it's Article 17. Article 17, we know it is an article where the old system, old Indian orthodox system has been questioned. When we say untouchability, literally it is not touching or not touching one. We have a very cultural context involved in this, and we have a system where we had faced many cultural complex things where the people has been humiliated on various aspects. So untouchability is not literally as we just see. ఇది చాలా డెప్త్ ఉంది ఈ వర్డ్కి. మన సమాజంలో we have seen many humiliations. సో ఈ untouchability అనేది ఆర్టికల్ 17ను అబాలిషన్ చేయబడింది. We have abolished untouchability according to article 17. So what is untouchability? Untouchability is not just a word, it is a practice. It is a practice which has been practiced for many years, for centuries. We have been practicing untouchability, but post independence we thought that in our modern constitution we should do away with the process of untouchability. We should do away with this heinous process. So we have made sure that article 17 addresses this. So this form of untouchability is forbidden. దాన్ని మనం తొలగించబడింది. ఈ untouchability అనేది చాలా ఒక రకంగా నేరమైన ప్రక్రియ. So we have enforced that no one is discriminated or no one is humiliated on the basis of this system. It may be a caste system or it may be any other things where a lower caste people, where he comes across other person, he could not discriminate. So untouchability has made a criminal offense. Untouchability which is not acceptable in this modern society. We have by article 17 abolished untouchability. So it is a punishable offense by law. So we have various things in untouchability. This also creates a sense of equality. Abolition of untouchability, where anyone, any section of the society can have a dignity of life. He can go anywhere, he can reside anywhere. So the abolition of untouchability has given a sense of dignity to the individual. He has given a sense of pride to any individual. So how this is practiced? Generally we see untouchability is practiced when someone is insulted. As I generally said, untouchability ante literally touch చేయడం అని కాదు. అది ఒక ప్రాక్టీస్, అది ఒక ప్రక్రియ, కొన్ని శతాబ్దాల నుంచి వస్తున్న అదొక హీనియస్ ప్రక్రియ. సో ఇన్సల్టింగ్ సమ్వన్ బై టేకింగ్ దేర్ నేమ్ ఆఫ్ కాస్ట్, నువ్వు తక్కువ కులం నుంచి వచ్చావు అని ఎవరైనా చెప్తే అది ఇన్సల్టింగ్గా ఉంటుంది. దట్ ప్రాక్టీస్ ఇస్ ఎనఫ్. సో దిస్ ప్రాక్టీస్, if someone says that, he is punishable according to the law. Or ప్రీచింగ్ అంటే దాన్ని ప్రచారం చేయడము, అన్టచబిలిటీని ఒక రకంగా ప్రచారం చేయడము, అది కూడా ఒక నేరము. సో దట్ పర్టికులర్ పర్సన్ కుడ్ బి punished according to the law. Or justifying untouchability, ఇది నేను చేస్తుంది కరెక్టే, అన్టచబిలిటీ మా సొసైటీలో చాలా సంవత్సరాల నుంచి ఉంది అని ఆ అన్టచబిలిటీని జస్టిఫై చేయడం కూడా ఒక రకంగా క్రిమినల్ ప్రక్రియ. సో insulting someone by taking his caste or by making caste as the basis, by insulting them, or by preaching untouchability, or by justifying the nature of untouchability. So all these things are offense, like they are punishable according to the law. So we have changed the word untouchability, and abolition of untouchability has been given another name, or it has been renamed in 1976 by making it as Protection of Civil Rights Act. this may be seeming something, awkward, that abolition of untouchability. So we have given a rename, we have given a new name by giving that protection of civil rights. Everyone has their rights. So civil rights are being protected by Article 17. Everyone is equal. No one is like from lower caste or from higher caste. When we say abolished untouchability, we are giving more civil rights to any individual. We are empowering them to move the court if he's been offended or affected by the words of someone. If he feel insults, he could move the court by proper evidence. So by insulting, preaching or justifying, if someone had hurt his sentiment, then that particular aggrieved person could move Supreme Court or High Court for his protection of civil rights. So in 1976 we have renamed this Abolition of Untouchability Act, or have we given a rename or new name as Protection of Civil Rights Act. Okay, this is another fundamental right. In right to equality, we have Article 18. Article 18 is prohibition of titles. Prohibition of titles is someone like we have had when we've been ruled by British, Sir, Bahadur అని కొన్ని టైటిల్స్ ఇచ్చేవాళ్ళు. అలాంటి టైటిల్స్ వల్ల we cannot have equality in the society. కొంతమందికి కొన్ని పేర్లు ఒక అపెండేజ్ లా, పేరు పక్కన సర్ అని ఉంటే అది ఖచ్చితంగా ఈక్వాలిటీకి దారి తీయదు. సో వీ హ్యావ్ అబాలిష్డ్ టైటిల్స్. వెన్ వీ సే అబాలిషన్ ఆఫ్ టైటిల్స్, ఇట్ ఈస్ నాట్ దట్ వీ ఆర్ నాట్ respecting them in terms of distinction or in terms of merit. We have many exceptions to this. For example, military కానివ్వండి, ఎడ్యుకేషనల్ డిస్టింక్షన్స్ కానివ్వండి, వాళ్ళకి ఈ టైటిల్స్ ఇవ్వచ్చు. ఫర్ ఎగ్జాంపుల్ వీ హ్యావ్ డాక్టర్. డాక్టర్ని డాక్టర్ అని ముందు పెట్టుకోవచ్చు. సో ఇట్ ఈస్ సమ్ సార్ట్ ఆఫ్ టైటిల్. బట్ అదర్ థింగ్స్, అదర్ titles given by any society, for example, cannot be used as appendage. So no title not being military, ఇక్కడ not being military or academic distinction అనేది ఎక్సెప్షన్. ఇది ఎక్సెప్షన్. ఇవి యూజ్ చేయొచ్చు, కానీ దీనికన్నే లైక్ ఎక్సెప్ట్ దీస్ థింగ్స్ వీ కెనాట్ యాడ్ దోస్ టైటిల్స్ యాజ్ అపెండేజ్. మన పేరు పక్కన ఆ టైటిల్ అనేది పెట్టుకోవడం ప్రొహిబిట్ చేస్తాం మనము. సో Articles 18 prohibits using of title. Here, no citizen of India shall accept any title from any foreign state. We cannot accept any title. వేరే కంట్రీస్ మనకి ఒక టైటిల్ ఇవ్వచ్చు, అది మనం యాక్సెప్ట్ చేయలేము. అదర్వైజ్ ఒక డిస్టింక్షన్ లైక్ ఒక పిహెచ్డి చేసిన తర్వాత డాక్టరేట్ అని ఇస్తే అది యూజ్ చేయొచ్చు. బట్ అదర్వైజ్ వీ కెనాట్ యాక్సెప్ట్ సర్టెన్ టైటిల్స్. So we also had a much debate on this. For example, government will confer Bharat Ratna, Padma Vibhushan, Padma Bhushan, ఇలాంటివి కూడా ఇస్తుంటాయి. సో అది కూడా టైటిల్ కింద వస్తుందా? We had many cases in that. But we say గివింగ్ డిస్టింక్షన్ టు అ పర్సన్, వాళ్ళ యొక్క వర్క్ని గవర్నమెంట్ గౌరవించి ఒక అవార్డ్, ఒక టైటిల్ ఇస్తే అది యూజ్ చేయొచ్చు. కానీ ప్రతిసారి వాళ్ళ పేరు పక్కన అది అపెండేజ్గా యూజ్ చేయలేము. వి కెనాట్ యూజ్ దోస్ titles every time as the appendage before their name. So accepting the distinction, they have been seen that they have been recognized by the government for their distinctive work. Adi service kanivandi, public service kanivandi, art, science, anything, they have been qualified for an eminent person, so that they have been awarded for their continuous effort in the society. But they cannot use that as appendage to their name. So we have prohibited using title because we are talking about right to equality. సమానత్వం గురించి మాట్లాడుతున్నప్పుడు ఒక మనిషి యొక్క టైటిల్ని పక్కన పెడితే డెఫినెట్లీ హీ విల్ బీ మోర్ ప్రివిలేజ్డ్. కానీ సొసైటీలో వెన్ వి సే ఎవ్రీ వన్ ఆర్ ఈక్వల్, దో దే ఆర్ క్వాలిఫైడ్, వాళ్ళ వర్క్, వాళ్ళ ఎఫర్ట్ని వాళ్ళ గుర్తించి గవర్నమెంట్ వాళ్ళని సన్మానించడం జరిగింది. బట్ ప్రతిసారి దే కెనాట్ యూజ్ దట్ అపెండేజ్. So that is Article 18, where we are talking about not using titles. So where we are discussing, we have discussed in fundamental rights, we are talking about fundamental rights, and here we are talking about right to equality. This is right to equality from Article 14 to 18. Very important. So we just have a brief revise of this subject. What is right to equality and what are these articles? Article 14, we have seen equality before law and equal protection of law. What Article 14 says? Everyone is equal before law and all the laws are equally applicable to everyone. So no one is above law. చట్టం ముందు అందరు సమానులే, చట్టం అందరికీ సమానంగా వర్తిస్తుంది. సో ఆర్టికల్ 14 టాక్స్ అబౌట్ ఈక్వాలిటీ బిఫోర్ లా అండ్ ఈక్వల్ ప్రొటెక్షన్ ఆఫ్ లా. వెన్ వి సే ఆర్టికల్ 15, we are bringing more equality by having equal access to the public areas. We are prohibiting discrimination on the basis of what? We are prohibiting discrimination on the basis of religion, race, caste, creed and place of birth. So here we are ensuring that social equality is maintained. That is Article 15. It's a brief thing. When we say Article 16, it is providing equal opportunity for public employment. Here we had many exceptions as we discussed. We will be discussing few questions on this, but equal opportunity in public employment. Here also we have many exceptions, that women, children or from economically weaker section of the society has been given certain reservations to give them an equal platform to compete with the privileged sections of the society. So Article 16 ensures that equal opportunity is given in public employment. Article 17 prohibits untouchability. It is the abolition of untouchability. Where we could get social equality, we have to abolish untouchability. So Article 17 has abolished this, and that could ensure a social pride, a social feeling for the individual. Article 18 has abolition of title. No one should take title or use it before their name. So there is an exception for this. Distinction in military or other services are being recognized. Other than that, no person should use their titles before the name. So this is the basis of right to equality. Right to freedom from Article 19 to 22. So as we all know, fundamental rights are mentioned in Part 3 of the Constitution from Articles 12 to 35. This is a small introduction regarding this fundamental rights. So what is right to freedom? We can say that for any democracy to flourish, for any democracy to be vibrant and dynamic, every individual should be given right to freedom, right to liberty, right to express their opinion. So here fundamental rights, and this part deals with right to freedom. We have 6 important rights here. Before that, we will say that in right to freedom, originally we had 7 fundamental rights. One fundamental right, namely right to property, that is to acquire, hold the property, has been repealed. The right to property has been repealed by 44th Constitutional Amendment Act. We can say that right to property was repealed by 44th Constitutional Amendment Act 1978. At present, we have only 6 rights. We have only 6 rights in Article 19. So what are those fundamental rights regarding Article 19? That is those 6 rights under right to freedom. Freedom of speech and expression, freedom to assemble peacefully without any arms, that is unarmed assembly is allowed, and formation of associations, that is formation of unions, formation of cooperative societies also is permitted. We have a right to freedom to form associations, and we can move in entire territory of India. That is free movement of any individual. So we have a free movement. We can reside and settle anywhere in the territory of India. And finally, we can practice any profession. That is, we can practice any trade, business, or any profession within the territory of India. And this, we can also have a business. We can conduct business anywhere in the territory of India. So all these 6 rights empowers any citizen. All these 6 rights empowers any citizen to develop individually, to develop economically, to have a moral aspect. So these rights, right to freedom, also enhances liberty, and it caters to the development of individual personality. And in overall, it's a comprehensive thing, so that it contributes to the development of the nation. We will be doing all these right to freedom in detail. Let us have one by one. So what is freedom of speech and expression? So freedom of speech is any individual has the right to give his opinion, or has the right to speech freely, to express their ideas, to criticize, to praise, whatever. So this freedom is guaranteed. This freedom, that is freedom of speech and expression, is guaranteed by the Constitution under fundamental rights. So when we say that we have a speech, freedom of speech and expression, we also have few exceptions to that. That is where we call it as a reasonable restrictions that we would be dealing in our coming topics. So here, freedom of speech and expression, this right is applicable only to the citizens. That means this right doesn't consider foreigners into them. So foreign people are not involved in this. So this right is not applicable to the foreigners. This also means that we have a complementary thing. We have international conventions on human rights, civil and political rights. So we also have international precedents or conventions which supplements to our Article 19. That is freedom of speech and expressions. Because we have certain human rights. Human rights are respected all over the world. So in India also, we have been inspired by liberty, freedom and fraternity. So we have given a constitutional status to freedom of speech and expression, and this is supplemented by many international conventions. Also, we respect human rights, civil and political rights, and as we know, freedom of speech and expression is a part of human right. It is a part of civil and political right. So we can say that we have been supplemented or inculcated the ideals of international level human ideals also. So this also includes freedom of press. In our constitution, we haven't exclusively used the word as freedom of press. We have implicit in freedom of speech and expression, which also gives freedom to press, freedom to publish, freedom to telecast, freedom to broadcast. So even freedom of press is also included in freedom of free speech and expression. So as we say, we have freedom of free speech and expression. We also have a right to criticize. Right to criticize the government, right to know what's happening in the government, right to criticize the authorities, right to criticize the bureaucracy. For example, we have a right to information. In freedom of speech and expression, every individual has the right to know what's actually happening in the government. Because what is government? Government functions for the people. By the people, they have been there. So it is all the right for any common individual to know what's actually happening in the government. So freedom to criticize, freedom to know what is happening, freedom to take the information is also included here. One more thing is when we say a right to speech, right to express, right to give opinions, or right to criticize, we also should think that not speaking also a fundamental right. We can not speak, someone cannot force us to speak. That is, making silence or maintaining silence is also part of fundamental right, that is freedom of speech and expression. So right not to speak or right to be silent is also part of freedom of speech and expression. So see the comprehensive nature of right to freedom of speech and expression. It involved both expressing one's view, and it also involved not to speak, not to give one's opinion. So maintaining privacy is also a fundamental right under right to speech and expression. So when we say that our constitution has given us all these rights, right to speech, right to express, right to publish, right to broadcast, right to have written journals and everything, but there is something which should stop any individual from violating these things. So we can say that the constitution has struck a balance between individual rights and societal rights. See, these rights are not absolute. Imagine if the constitution gives absolute rights to the individual, they may be misused or they may harm some others' fundamental rights. So the constitution has also limited these rights. So the constitution has in itself provided few limitations so that these fundamental rights, or importantly freedom of speech and expression, is not misused. So we can say that the right is subject to reasonable restrictions. Here when we say reasonable restrictions, the constitution has itself allowed to make few parameters to restrict the freedom of speech and expression. Unlike in United States of America, where the Bill of Rights which guarantees the fundamental rights, limiting these Bill of Rights are no Congress has power to limit the Bill of Rights. That is, legislature in United States of America doesn't possess power to restrict the freedom of speech and expression. It is left to court, it is left to judiciary. But in India, we have given power to the legislature itself. We have given power to the legislature itself to restrict or to make a boundary, to create a limitation, so that these freedom of speech and expression are not misused or they are not used to hurt others' rights or others' emotions. So our constitution has made it clear. Our parliament says that there should be a balance between individual freedom and societal freedom, that is societal liberty. If a particular individual has given absolute right, he may misuse those rights or may cause harm to other people's rights. So we also have reasonable restrictions on individual rights. So we cannot say that the fundamental rights guaranteed by constitution are absolute. They are not absolute. They can be limited by parliament. This is mentioned in Article 19(2). And we have various Supreme Court judgments regarding this, where we have used the word restrictions or reasonable restrictions. For example, we have few cases like we have case like Brij Bhushan versus State of Delhi, where we have the Supreme Court has said that there can be limitations on these right to speech and expressions. In coming topics, we would be discussing these Supreme Court cases. Like we also have cases of Brij Bhushan, Virendra versus State of Punjab. So all these Supreme Court cases have given an idea so that the legislature could limit the freedom of speech and expression. So what are those reasonable restrictions? What will form, or what could be the elements which restricts these freedom of speech and expression? First thing is, when any act of the individual disrupts the sovereignty and integrity of India, then they can put, or the parliament can, by reasonable restricting those powers, could prohibit those things if the act of any individual affects the sovereignty and integrity of India. The other element is where there is affecting security of the state. Otherwise, we can say any act of an individual affects the security of the state, then those acts can be curtailed or restricted. So sovereignty and integrity. Sovereignty is what? Sovereignty is the independent power of any country to prepare its own laws, to make its own policies, to run the government. So if any act of an individual affects the sovereignty and integrity of India or nation, then such acts can be curtailed or limited by the legislature. In the same way, if any act of an individual or a group of individuals affect the friendly relations with foreign states, such acts can be restricted by the legislature. So it is not that freedom of speech and expression are absolute. We have limited those rights in these cases. In the case where we have an effect on security and integrity of India, when we have effect or threat to the security of the state, or if there is a threat to the friendly relations with foreign states, or any speech or any expression, maybe in terms of writing or audio or speaking, anything which affects the friendly relations with foreign states or foreign countries, then such speech can be restricted or such speech can be curtailed or limited. We also have other criteria, that is public order. When we say that any act or any speech of an individual affects the public order, or there creates a disorder in the society, or the law and order problem is arised because of such speech and expression, then legislature could curtail those acts or could restrict the freedom of speech and expression. We also have other element where we can use reasonable restrictions. We had seen where there is an effect on sovereignty and integrity of the country, where there is an effect on security of the state or security of the nation, and we can say that when there is an effect or there creates a problem with friendly relations with foreign states, we can use those reasonable restrictions. And where there is a public order is not maintained, or where there is a disruption of public order, then also we could use reasonable restrictions to limit the freedom of speech and expression. The other element is decency and morality. In the name of decency or morality, if any speech or expression is affecting the decency and morality of the society, or the general fabric or culture of the nation is disrupted, then the legislature could restrict such speech, such right of freedom of speech and expression by using its tool of reasonable restrictions. For example, when we say if there is a content in any movie or in any video where the morality of the people is disrupted, then the government can use the censorship to curtail or restrict such content in video or in any other format of electronic media. So what is contempt of court? For example, if any case is prejudice, any expression of speech is against the court's values or against the court's integrity, then such speech or expression can be limited by using reasonable restrictions. Though the aggrieved person cannot go to the court saying that my freedom of speech and expression has been violated. Yes, these are the exceptions. These are the exceptions where the legislature could use its power to restrict the freedom of fundamental rights and freedom of speech and expression. So this is one. Here contempt of court is when an individual ignores the court's procedure and he freely expresses something which is prejudice or which is in the judiciary. So contempt of court is a serious offense where the court could punish that person with imprisonment. Other factor is defamation. It is not that when you have freedom of speech and expression, you could talk anything. You could talk regarding a person, anything which is not actually in real. So you are defaming such person by your freedom of speech and expression. You are not responsibly using the right to freedom on speech. So here defaming is you are hurting some other person's sentiment. You are defaming his name in the society. So that such person who gets offended can move court and can say that those freedom of speech and restriction could be curtailed. So freedom of speech and expression are not absolute. So these are few of the things which could give power to the legislature to restrict the freedom of speech and expression. One another thing is incitement to an offense. You cannot just because you have freedom of speech, you could speak anything. You have to be very careful with your words. See, freedom is given for our own responsibility. We have to use that freedom for good of our family, for good of our individual personality, and for the good of the society at large. It should protect the larger interest of the people. But generally what happens is, we generally see in any political rallies or processions, we would see some people speak something which becomes a base for some religious clashes or some political chaos. So that may result in incitement to an offense. Because of that speech, some clashes could have happened. So this is also becomes a base for restricting the fundamental right of freedom of speech and expression. So these are all few reasonable restrictions the legislature could use to contain or to limit the freedom of speech and expression. So what is the question of reasonableness? So we have to know how the reasonableness is judged. Who will judge the reasonableness of any freedom of speech and expressions limitation power? So definitely it is, the court, the higher court, both Supreme Court or high courts will decide on the reasonableness of the restrictions. See, in legislature could use its power to restrict the freedom of speech and expression. As we had before, when emergency was imposed in India by Indira Gandhi government, we have seen lot of limitations on freedom of speech and expression. It was actually misused. The legislature has misused the power of its authority, and it has imposed a lot of restrictions on these fundamental rights. So when we say reasonableness, it is up to the court to decide how element of reasonableness is actually working. So court says that it has to be determined by two things. One is substantive and one is procedural. That is, when a legislature will bring a law to restrict the freedom of speech and expression, it should be both substantive. Substantive here in sense, the effect caused by such law should not be more, or the restrictions placed on freedom of speech and expression should not be higher than actually the effect of the law, the freedom of speech and expression. See, substantive here is whenever a legislature brings a law, should be in coordination with the actual freedom of speech and expression. So here the court will see the substance of that reasonable restriction of the legislature which has controlled or limited the power of or the freedom of liberty, freedom of speech and freedom of expression. When we say procedural, it means the court will see that what process the legislature has used, to contain or to limit the freedom of speech and expression. Fundamental rights. Under fundamental rights, we were discussing Article 19, right to freedom of speech and expression was a part of Article 19(1). Freedom here, when we say right to freedom, in right to freedom, we have freedom of speech and expression that we have discussed in our last class. Here, freedom of press. In our constitution, we do not have a special provision regarding freedom of the press. Here, press may be electronic media, newspapers, journals, or any such content which is published, broadcast, or supplied in public. So, for freedom of press, we do not have any special provision in our constitution. When we say freedom of speech and expression, it itself is a larger concept which includes freedom of the press. So the freedom of speech and expression is in itself an umbrella concept which includes freedom of the press. But here when we say Press Objectionable Matter Act 1951, there was an act actually which restricts the press for not publishing anything which is objectionable, that was decided by the parliament or by the legislature. So after expiry of this act, Press Objectionable Matter Act 1951, after expiry of this act, Indian legislature or Parliament of India has brought a law, Prevention of Publication of Objectionable Matter Act 1976, that is, in the days of emergency. In the days of emergency, this act was enacted or this law was brought, that is, Prevention of Publication of Objectionable Matter Act 1976. Here, we cannot say that the legislature or the parliament has used its power to curtail fundamental rights. One thing we need to understand that fundamental rights are not absolute. There can be a reasonable restriction or then there can be imposed certain limitations on these rights by the state. So using that power or authority of the parliament, the government has passed this law, Prevention of Publication of Objectionable Matter Act 1976. So by this, we can say that the government may also use this power to curtail freedom of speech and expression. Here, the freedom of speech and expression to let the people know what's happening in the government may be disrupted. After this, when Janta government has came, it has repealed this act or repealed this law, saying that it has encroached on freedom of speech and expression. Censorship is one such topic. Censorship is one such topic where the government uses its authority to limit or to place certain limitations on the freedom of the press. Here censorship may be on newspaper, maybe on any movie, or maybe on any content which is circulated in the public. So here censorship is scrutiny. The scrutiny is done before publishing by a body of expert. They will look into the details of such content, and only after they are satisfied that this content can be published or this content can be broadcast, they will give a certificate. So censorship is such a tool which is in the hands of government, where in some cases it could restrict or place limitations on freedom of speech and expression. This has been mentioned in many Supreme Court judgments. We had a case of Brij Bhushan versus State of Delhi. We also had a case Ramesh Thapar versus State of Madras, where the Supreme Court has said that the state could use its power of scrutiny, but it should be of reasonable restrictions. That is, it should not be against natural justice. That is, see, in censorship, the government wants a scrutiny of the content before they publish. So the Supreme Court's judgments has also formed a basis for reasonable restrictions. It has says that the government should follow certain principles of natural justice, not totally affecting the freedom of speech and expression. We can also say that in various countries like United States of America, like United Kingdom, where right to speech, freedom of speech and expression, liberty has been given utmost important. So the government do not generally involve in restricting the media or restricting the press in terms of normal conditions. When there are normal conditions, that is, when the country is not in emergency or when the country is not involved in war, in such normal conditions, the government cannot place restrictions on freedom of press. But in our country, in India, in normal conditions also, that is, when we do not have emergency or when our country is not at war, in such normal conditions also, the government could place restrictions on freedom of press. So here, because such a thing is there, that was the Supreme Court has given in Virendra versus State of Punjab. This was the case where Supreme Court has admitted that government could impose reasonable restrictions on freedom of press, where the content is causing harm to public order. It says that the government could restrict. So this has been a few cases, and after that immediately the government has amended the constitution and it has added the word public order in reasonable restrictions. So continuing with it, public order, when there is any content of any media, any newspaper which affects public order or which promotes hateism or which causes for communal clashes or chaos, so that there is misorder or law and order is affected, then the government could involve and place reasonable restrictions and could affect the freedom of speech and expression. So we have a power with the government that it could limit the freedom of speech and expression. We also know that right to information, what we have the Act RTI, it's a major enactment of this. So freedom of speech and expression also means that a common man or an individual has the right to know what's happening in the government. What are the government policies? How much the government has spent? The money the government has spent is actually used for such work. So every common man has a right to know what's happening in the government. So right to information is also such an enactment which has added more strength to freedom of speech and expression. So we can say that this freedom of speech and expression is the most basic element for overall development of individual, overall development which contributes for the growth of the nation, which is against the parochialism of the people, or which also adds for a vibrant democracy, a flourishing democracy. So this is an important element in the entire fundamental rights, the right for freedom of expression, which gives a democracy a very true color. Continuing with this, the next is freedom of assembly. This is a part of right to freedom under Article 19, freedom of assembly. You know what is assembly? Assembly is meeting at some place or where we have a meeting with a group of people. So holding public meetings, demonstrations and taking out processions like rallies, like we can say sit-outs, or to assemble just to express their views. So freedom of assembly is where a people with common goal meets at one place and they have few discussions which they will generally give a message to the government. This is a platform where one's grievance is explained or where grievance is known to the government. But as we say, we have reasonable restrictions. Government can place or the legislature can place certain restrictions on this freedom of assembly. That is, if the assembly disrupts the law and order, or if the assembly has a plan to disrupt the public order, then there could be placed restrictions on those freedom of assembly. So here freedom of assembly, if it is not causing any harm, until then it's okay. But if it is not valuing the public order or not valuing the peace and harmony of the society, then such assembly could made illegal. So it has to protect violent. To protect violent, the government could place certain restrictions on this freedom of assembly. So it has to be more orderly. It has to be orderly. It should not be riotous, like there should not be any clashes, and the assembly should be without any weapon. So arms should not be allowed in the freedom of assembly. people should assemble without any arms. So here we can say that state can impose reasonable restrictions where there is a threat to sovereignty and integrity of the state, or where there is a threat to maintenance of public order, or there is a threat to the security of the state. So in this case, in freedom of assembly, the government could use its power of limiting the freedom of assembly by inciting the words of public order or maintenance of traffic in the area. So if there is a traffic problem, if the assembly causes traffic jam in certain cities or places, then the government may not give permission for those who decides to assemble at that particular place. So government may restrict the freedom of assembly if it causes disruption to the general life of the people, or if it causes a violent sort of nature, or the order is disturbed. So in this we can say that Section 141 of IPC, Section 141 IPC has given few things so that it could justify its restriction or reasonable restriction. Where, see, there are acts which are unlawful. When such acts becomes unlawful, they can be restricted. So assembling of 5 or more persons, when we can say in under Section 141 of IPC, the government will not give permission if it is assembly of more than 5 persons. So that would cause, if any assembly causes problem or destroy of property of some persons, or a plan to behave in such a manner that destroys or commit any mischief, and if the act is illegal, and if there is a threat to any government official, then under Section 141 of IPC, the permission is not given to such assembly. So these are few restrictions on freedom of assembly. We can also say that under Section 141 of Criminal Procedure Code, a magistrate can give orders. To restrict that assembly, to restrict that meeting of the people, so that if there is a threat to human life or public property or harmony in the society. So Section 144 of CRPC, by using this section, a magistrate or a district collector also could issue such orders to not give permission for assembly of such persons where we have a threat to human life, threat to public property, or threat to the peaceful existence of the society. So these are few restrictions on freedom of assembly. So that was 19(1)(b). 19(1)(a) was freedom of speech and expression. 19(1)(b) was freedom of assembly without arms. Now we have freedom of association. Forming an association or forming a union or creating a cooperative society are fundamental rights enshrined in our Constitution. For growth of common individual, it would be always better that they form a union so that they create a sense of unity among themselves. They could fight for their justice. They could also express their demands. So associations and unions are always a part of democracy, where one could have a collective bargaining, or one could form a pressure on the government to get their demands done. So Article 19(1)(c) is such an article which gives right to form associations, to form unions, or to form cooperative societies. On this fundamental right, that is on freedom of association, the government or the state can also give reasonable restrictions. The state can also restrict the formation of associations on some conditions. If the association is illegal, then the state may restrict to form such an association. So if the association is illegal, or if the association is not in the larger interest of the people, then the state could restrict such associations. Or if the association takes away the individual freedom, then also the state will restrict such associations to get formed. Or when there is a threat to public order, or when there is a threat to morality or sovereignty of nation or integrity of the state, then the state could use its power of reasonable restrictions and may not give permission for the formation of such associations. So we can also say that forming an association is good in democracy, but it should not violate certain basic things. Like formation of association doesn't mean that you got right to strike. So the right to strike is not a fundamental right. The government could prohibit such a assembly or such a association where it takes on the strike. Or we cannot say that calling for a bandh is also not a fundamental right. So declaration of lockout is restricted by the state under this Industrial Dispute Act or Trade Unions Act. We have an act which specially says that lockout, going to strike, is not accepted. So right to form association does not carry the right to recognition. Yes, you can form association for a specific problem, but it does not mean that you have a right to recognition. And we also already said that this does not mean that we have a right to carry strike. And we also say that right to form an association does not carry the right to inform rival union. So these are a few restrictions mentioned by the state or given by the state on freedom of association. Freedom of association should be legal, should be for a common cause, and should not be against the state or should not be generally against the interest of the larger section of the society. The next fundamental right under right to freedom is freedom of movement. Freedom of movement. Before this, we can say that we have done with right for free speech and expression. We have fundamental right, freedom of free speech and expression. We've done with freedom of assembly. We have done with freedom of association, forming unions and all. Now, the next freedom in Article 19 is freedom of movement. Here, freedom of movement is a common man or any citizen can move throughout the territory of India. He has all the rights to move or travel to entire India. Like he can move, he can travel through the territory of India. But when we say that, the state also says that there are certain limitations for that. For the movement also, there are certain limitations. When we have freedom to move in any part of the country, in any region of the country, because we say that the few people lives in few pockets of our territory. For example, when we say northeast India, we have a good amount of tribal population there whose culture are generally different from other parts of the India. When we say that in central India, we have a huge forest area where the population lives, their culture is quite different from the culture of other parts of India. We also have tribes who lives in Andaman or surrounding areas where their culture, their habit is quite different. So here freedom of movement is restricted by the state, because that movement, anybody's movement and encroaching in those territories could affect their cultural problems. We can also say that their distinctive culture could be disturbed because there is a movement or encroachment of people into their culture. So they may not easily accept that. So government has made that the state could restrict them or could put a reasonable restrictions not to enter in such areas, especially when we say that the general public, the interest of the general public is disrupted. There the state could restrict this fundamental right. Or when we say that the scheduled tribes people in agency areas or in deep villages, there the movement is restricted by the state. So when we say freedom of movement, yes, any citizen could move freely in entire territory of India, but the state can also at the same time restrict the movement in certain areas where the people has their distinctive culture, where the people has their unique identity that they could not generally ready to give up their culture. So the state can restrict the movement of those persons in these areas. Freedom of profession. It is again one of the freedom of profession is one of the right where a person or a citizen can have a right to profess anything or to do any job or to get into any business or to get into trade, because freedom of profession is a person can choose any profession for his livelihood, for their livelihood. But the restriction here is when we say freedom of profession, few things or few eligibility conditions are there which the state could decide. For example, if there is a technical thing, there should be a technical knowledge or technical certificate that is suited to do the job. For example, to do a surgery, a person should have a certificate. He should be a surgeon to perform an operation. So it is not that easy that any person could do any job. So you should be certified by concerned agency. You are qualified for that particular job. Then only you are eligible to perform such functions. So the government could place reasonable restrictions, that is an eligible condition for doing such type of job. So here professional qualities are necessary to do a required work or to carry on any business or trade. You should have certain qualifications. We can also say that in some areas the government has complete monopoly, and there individual cannot say that the government has restricted a citizen to enter into that area. Because the government is monopoly, the government can restrict few persons, and we cannot challenge the state so that it is monopoly and it is restricting the freedom of profession. So these are few restrictions where the state will impose certain limitations, right from qualification to eligibility conditions, so that the freedom of profession is not misused. And this also means that freedom of profession is where a person cannot get into such jobs which is illegal or which is not moral or which is not acceptable in the society, such as prostitution. Here it is not a profession, it is against morality of the society. So the government could restrict movement of such persons, or taking that as a profession, the government could restrict such things. And where the trafficking of women or children is involved, it is a profession which is not acceptable in the society. This profession or this way of doing business is not acceptable, and it is illegal. So the government could place restriction on such activities which are not acceptable in the society, which is against the ethics and morality of the people, and other such activities where there is a supply of drugs or explosives, which generally is a threat to the integrity and unity of India, or there is a threat to public order or threat to peace and harmony of the society. Such acts can also be restricted by the state. You cannot just say that I was doing my business and Constitution has given me freedom to profess any activity. So here, which the things which causes harmful to the society, those things can be restricted by the state. So fundamental rights are mentioned under Part 3 of the Constitution from Article 12 to 35. So we've already discussed what is Article 12. It defines state. It defines what is state. So in state, we have parliament and central government, assembly, state government, all the local governments, all the statutory and non-statutory bodies, all these things comes under state. So we have discussed Article 14, that is right to equality, from Article 14 to 18. We have in detail discussed these articles. We are now discussing right to freedom. We would be discussing, yes, Article 20. So in last class we have already discussed Article 19, Clause 1, Clause 2, various reasonable restrictions, freedom of press, and all those grounds on which the legislature or the parliament could impose restrictions. So when we say Article 20, this article is equally applicable to both citizens and foreigners. This article protects in respect of conviction of offences. For example, if anyone is convicted of any offence, that particular person have some rights, because we follow law of the land. We follow procedure established by the law. So there is no chance or no place for arbitrary arrest or arbitrary detention of any particular person. So a person should only be punished for the act he has been done which is against the law. So the law should punish to such an act. So there is no place for arbitrariness here when we say protection in respect of conviction of offences. Any citizen or foreigner, this act applicable to both citizen of India and foreigner. So we have three things here. Basically this says protection in respect of conviction of offences, that is, executive may go 2 steps behind what actually legal thing says. They may use their arbitrary power, their discretion, which may be illegal. So in that sense, a common man could approach court. For example, we have no ex post facto law. We need to I brief you what is no ex post facto law. Here this means the law should not be applicable retrospectively. For example, a crime has been done today and there is a law made next day, that is after today. So that particular person should not be punished on the basis of the new law, because when the crime had happened, when the crime has happened, there was no law. The law brought the next day, or not on the day, the next day. So that person should not be punished by the new law. Otherwise, I could say in this way, the person and his act, his or her act, should be punished on the basis of law of that point. If the law is existed on the time of offense or the time of crime, such law will only applicable for any legality or for their prosecution. At the same time, there is also a clause that if the penalty is imposed on such person for such crime, that penalty should be equal to the penalty of that day. So there is no retrospective punishment. So post facto law is before, after the law, but not back. So here retrospective is important. No retrospective law. There is an exception for this. No ex post facto law. Here it is applicable only to criminal cases, not for civil or other cases. So for civil cases, there could be retrospective law. For civil cases, there could be both retrospective and prospective law. But for criminal things, only prospective. For criminal cases, only prospective law. So this is what ex post facto is. We'll again go into this in detail. When we say no double jeopardy, what does it mean? We say no double jeopardy is no person should be punished twice for the same crime. That is, if a person indulges in a crime, the court should not punish that particular person more than once for the same act he has done. So that is double jeopardy. This is generally not in our constitution. We say this word we have taken from Western constitutions. So double jeopardy is no person should be punished more than twice for the same crime. This again we'll see. No self-incrimination. No one should made himself or herself self-evidence. That is, no one should be forced someone to give evidence against themselves. So self-incrimination is evidence should not become that particular culprit or the person who has done the crime should not become evidence of his own. So no self-incrimination. We have few exceptions of this. We will be doing this in detail. When I say no ex post facto law, this is applicable only for criminal cases. When I say no double jeopardy, this is also applicable for criminal cases or the cases which the punishment is done by the court, by the judiciary. Otherwise, here any punishment by administrative or departmental things is not covered in double jeopardy. That is, they are exempted. They can give two punishments for the same crime. This we will be seeing in detail. No self-incrimination. Here also we have few exceptions. That is, the agency, the enforcement agency like police or any such agency could collect fingerprints, blood samples, or they could ask for body demonstration. So that is not making a person to give evidence against themselves. So we have few exceptions on this. But main thing what we need to remember is when we say protection in respect of conviction of offences, we have these three things: no retrospective law for criminal cases, no double punishment for the same crime, and a person cannot make themselves as a evidence for the crime he has done. So no self-incrimination. This we will be doing in detail. So when we say no ex post facto law, so here what is this? We are limiting the executive agency. We are limiting the executive agency, otherwise the constitution is limiting the executive agency to not be arbitrary. So it is a limitation imposed on the executive to not use its powers arbitrarily, because we have to follow natural justice, we have to follow law of the land, we have to have also to follow human rights. So we need to follow few things where the law is not used against the natural justice or fundamental rights of the citizen. So these are the limitations. But when we say no ex post facto law, it is just on criminal laws and no civil law is covered. Example here I would say, if a government comes with a municipal tax or collection of tax, for example, in 2021 the government says on December 1st, 2021, the government makes a law that the tax has increased by 5%, and this increased tax is applicable from 2020 of January. So it is a civil thing and it is a retrospective, because the government is collecting taxes from almost 1 year retrospectively. So people have to pay from 2020 January. But in criminal cases that is not the case. The government cannot say, or the judiciary, the legislative cannot say that you are punished. Actually, before the law has come, the punishment or the crime of any person is applicable on the basis of the law of that date. They cannot be retrospective. So here when we say no ex post facto, we are talking about retrospectivity. In criminal cases, that retrospective law does not appear, or we cannot make retrospective law in case of criminal law, but it is applicable in civil, maybe tax and that thing. We have an example when we say tax laws. We can give an example of Vodafone. We know Vodafone was a mobile service provider, and when Pranab Mukherjee was finance minister, he had imposed a retrospective law and Vodafone had to pay the tax. So these are the some examples regarding retrospectivity of few law which are applicable in civil or tax laws. Ex post facto law, this is applicable, it is not applicable in case of preventive detention. So we will go into this. What is preventive detention? What is punitive detention? Punitive detention is when there happens a crime, a court will punish on the basis of that crime. In preventive detention, a person could be detained before making any crime, or actually crime is not done, but to prevent that crime to happen on the basis of suspicion, one can be detained by the enforcement agencies for some period. Actually it was 3 months, now we have reduced to 2 months. So this we will be discussing. I hope this is clear. No ex post facto law which is applicable only for criminal law, and this element this element protects a person from offenses he has done or from arbitrary powers of the executive. So what is this double jeopardy? No double jeopardy is where a person is protected by this Article 20. Double jeopardy is no person should be punished for the same crime dual time. So dual punishment is not applicable or not made, or it is illegal. So we say no person shall be prosecuted or punished for the same offense. Offense is same. That is more than once. More than once, no one should be punished. Actually, any person who commits a crime may be punished lower, or the punishment could be smaller than what is prescribed in the law. But a person could not be punished more than what is prescribed by the law, or should not be punished twice for the same crime. Yet sometimes the court may let a person go, though he has made a crime, but on certain basis, maybe looking for his good future or to bring some reform in that criminal, the court may sometimes let them go, but should not punish more than prescribed by the law. When we say double jeopardy, that is for a single crime, the same crime, he shouldn't get punished twice. This is only if the proceedings are before the court or quasi-judicial body like tribunals. Here only is this punishment, that is double jeopardy, may be applicable when the case is before department. We have few departmental inquiries or departmental proceedings or administrative actions. On these things, a person can be punished twice. For example, when we say any public or government officer has done some crime, let us say has a corruption case on him and judiciary has already punished him, for example, sent 6 months to jail. On the same person, the department in which that particular person is working could also take some action. The department could proceed him and says that you could be demoted, or your promotion is stopped, you could be issued notice, or the amount which has been there, which has been a corrupted amount, could be brought back. So these are few actions the department could be taken. So we can say that even judiciary has punished him for example 6 months of jail. For the same person, even department can take those actions on him. So this is double jeopardy, which is applicable only for proceedings before a court or quasi-judicial court. There are tribunals. They are not applicable. That is, double jeopardy are not applicable when the proceedings are before department or administrative authorities. So there could be again departmental inquiries on the same crime on which already judiciary or court has given a judgment or sentenced that particular person. So this is an exception, and we could expect a question from this area. There might be a confusion in this. Judicial proceedings, no double jeopardy, only before judicial proceedings, that is before a court or quasi-judicial body, but not before departments and administrative agencies. So I think I am clear in this. No double jeopardy is no dual punishment for the same crime. So this is no self-incrimination. The protection against self-incrimination, that is making the same person who has involved in the crime to be evidence. So he have to accept his crime. That is what self-incrimination is. This can be misused This can be misused, as we generally see. We have custodial deaths, we have tortures in police station. Why? There may be reasons that the same person may be forced, may be used third degree to accept his crime, though he may not involved in that crime. But due to this third degree punishment or torture in jail, he may by force agree to the charges. So the court, in front of court, these evidence is or not valid. So court could say that these evidences which has given by that particular culprit or victim or that person who has been in offense is not valid. So that is no self-incrimination. However, this thing will not extend to few things, that is the department or the enforcement agencies like police, we can say income tax department, enforcement department, ED, CBI, ACB, or any such enforcement agency could collect the material evidence from that person. So that doesn't mean they are self-incriminating. So that person has a responsibility. Now he has to cooperate with those enforcement agencies to give whatever evidence for what they ask. They may be like in the form of hard disk, in the form of pen drive, in the form of files, in the form of CC footage, or whatever the enforcement agency asks, that person should cooperate and produce in front of them. They may themselves get interrogated. Police may interrogate, they have to cooperate in front of police. So that doesn't come under self-incrimination. So compulsory production of material objects is not under self-incrimination, and a person can be said to give their thumb impression, their iris, their specimen signature, blood samples, DNA, anything. So that doesn't come under self-incrimination. We can also say that sometimes police may ask to exhibit their body in private because they want some evidence. They are to collect the evidence. If the case is regarding any crime like murder or something else, then there will be a forensic people asked for the compulsory exhibition of the bodies. So it only extends to criminal proceedings. So we can say that self-incrimination extends to only criminal proceedings. Here there are many things in self-incrimination or no self-incrimination where the judiciary has said that this doesn't think, like when police use few techniques like narco-analysis, psychoanalytical procedures, lie detector, brain mapping, or any such things like truth serum. So these are the techniques where a victim or where the person is able to tell the truth, but there is no scientific validity on such techniques, and the Supreme Court has said that these evidence are not purely based on scientific, that they may not be valid. So we have no self-incrimination. So these are the few fundamental rights under Article 20 which protects a person of offense. So no ex post facto, no retrospective law, no double jeopardy, that is no dual punishment, and no self-incrimination, or the three things which protects a person from arbitrary or illegal, irrational action of the executive agency. So having said this, we would be discussing the next fundamental right, and in right to freedom, that is Article 21. We would be continuing with fundamental rights, that is Article 20 and 21. Article 20, it is against illegal detention, against offences, conviction of offences. We have already discussed this. This article is applicable to both citizens and foreigners. Indian citizens తో పాటు foreigners కూడా అప్లై అవుతుంది. Here Article 20 which has against offenses, like if any person indulges in any offense, how he could protect himself. ఒక వ్యక్తి ఏదైనా పని చేసినప్పుడు, ఒక అఫెన్స్ పని చేసినప్పుడు జ్యుడిషియరీ కానీ అడ్మినిస్ట్రేషన్ కానీ అతని మీద చట్టరీత్యంగా ఏదైనా చర్య తీసుకుంటే, ఒకవేళ ఫండమెంటల్ రైట్స్కి అగేన్స్ట్గా ఉంటే వాట్ ఆర్ ద రెమెడీస్, ఏ రెమెడీస్ వాళ్ళు ఫాలో అవ్వచ్చు, పాటించవచ్చు. సో మనం చూసాము ఎక్స్ పోస్ట్ ఫ్యాక్టో లా అనేది. ఎక్స్ పోస్ట్ ఫ్యాక్టో లా అంటే పోస్ట్, దట్ ఈస్ ఆఫ్టర్. We can, any person who does a crime or who does an act is subjected to such sections or such punishment which is mentioned on that day or on that time. ఆ రోజు ఉన్న చట్టం ప్రకారం మాత్రమే ఒక వ్యక్తి శిక్షకి అర్హుడు. అదే కానీ రెట్రాస్పెక్టివ్గా క్రిమినల్ కేసెస్లో మనం చట్టాన్ని తీసుకువెళ్ళలేము. సో ఇన్ క్రిమినల్ కేసెస్ నో ఎక్స్ పోస్ట్ ఫ్యాక్టో లా. ఆ రోజుకి వెనుక అంటే వెనుకలో ఉన్న చట్టాన్ని మనము తీసుకురాలేము. ఓన్లీ ప్రాస్పెక్టివ్, ఆ చట్టం రోజు నుంచి ముందు వరకు అమల్లోకి ఉంటుంది. దట్ ఈజ్ ఎక్స్ పోస్ట్ ఫ్యాక్టో లా. ఇది ఓన్లీ క్రిమినల్ కేసెస్కి మాత్రమే వర్తిస్తుంది. This ex post facto law is applicable only in criminal cases, not for civil and administrative cases. For example, when any government employee indulges in any crime or he is punished in any crime, then both judiciary and also department could take actions. This is ex post law and double jeopardy. What is double jeopardy? No person should be punished. As I said, no person should be punished twice for the same crime. ఒకటే క్రైమ్కి రెండు సార్లు పనిష్మెంట్ అనేది జరగకూడదు ఆర్ ఇవ్వకూడదు. సో నో డబుల్ జెపార్డీ. ఈవెన్ దిస్ ఈజ్ అప్లికబుల్ ఓన్లీ ఫర్ criminal cases and not for civil or administrative cases. No self-incrimination. తనకు తానే ఎవిడెన్స్గా మారకూడదు. సో దిస్ ఈజ్ మోస్ట్లీ అప్లికబుల్ ఇన్ పోలీస్ ఏజెన్సీస్ కానీ కస్టోడియల్ టార్చర్స్ కానీ. ఒక మనిషి ఏదైనా క్రైమ్ చేస్తే అతను స్వయ నిర్ధారణ చేసుకోవడానికి వీలు లేదు. That particular person should not made himself evidence for the crime he has done. It is not valid in front of the court. So a person could not be forced, tortured both physically and mentally to become evidence for himself. So that is no self-incrimination. These three are the things where a person could protect himself or herself in respect of conviction for any offense. So Article 20 is important in terms of protecting oneself when there is any criminal things which is imposed by agency. Agency might be any enforcement agency, be it police, CBI, ACB, any enforcement agency which illegally makes charges and makes a person a self-evidence. So these things can be protected. It is provided in our constitution, and Article 20 is very powerful when it comes to self-liberty or freedom of one person, self-person who is indulged in any offense. We'll move to next article. This is, we have already explained. So Article 21. Article 21 is very important article in our constitution. Even judiciary says that Article 21 is a lifeline of fundamental rights. Even we can say that Article 21 comes under golden trinity. That is, it is one of the Article 14, Article 19 and Article 21. These three article forms a golden trinity. చాలా ఇంపార్టెంట్ ఈ ఆర్టికల్. రైట్ టు ఈక్వాలిటీ, ఆర్టికల్ 14, రైట్ టు ఫ్రీడమ్, ఆల్ దోస్ ఫ్రీడమ్స్, రైట్ ఫ్రమ్ ఫ్రీడమ్ ఆఫ్ స్పీచ్ అండ్ ఎక్స్ప్రెషన్. ఇన్ ఆల్ దీస్ we have many things like right to form associations, right to assemble, right to move anywhere, right to settle, and right for occupation. So all this included in Article 19 and Article 21, that is protection of life and personal liberty. Very important, ఇది చాలా ముఖ్యమైన ఆర్టికల్. when it comes to life and personal liberty, Article 21 is one of the golden trinity. Without protection of life, a citizen cannot enjoy his life in a particular manner. He should not have threat to his life so that he is limited for his actions. ఒక మనిషికి జీవించే స్వేచ్ఛ ఉన్నప్పుడే అతను స్వచ్ఛందంగా ఏదైనా పనికి పాల్గొంటాడు, లేదంటే హీ విల్ వర్క్ ఫర్ సంథింగ్ బెటర్ ఇఫ్ హీ డజంట్ హ్యావ్ థ్రెట్ టు హిస్ లైఫ్ ఆర్ పర్సనల్ లిబర్టీ. We can also say that this article cannot be easily taken away because we have many things, many provisions mentioned in our constitution. Two important things here is life and liberty. No person shall be deprived of his life or personal liberty except according to the procedure established by law. Here this is the important thing, procedure established by law. No person shall be deprived of his life and personal liberty. That is, we have a procedure. We have a procedure mentioned in our constitution in also various things, like we have IPC, Indian Penal Code, we have Criminal Procedure Code, we have Civil Procedure Code, and we have many other manuals. We have service rules. All are mentioned somewhere, and base is constitution. So if you does any crime, if any crime is done, so according to the provisions mentioned in all those sources, according that source only a person should be punished. Otherwise, there should be no arbitrary action. There should be no irrational action against any person. So whatever procedure we have established by law, by that procedure only a citizen or any person should be punished. That is, no person shall be deprived of his life and his personal liberty. This thing, procedure established by law, we have taken from Japan constitution. We have taken this from Japan. We have one another thing also, that is due process of law. There is a difference between procedure established by law and due process of law. Very important, we need to know the difference between procedure established by law and due process of law. This we have taken from American Constitution. So what is the difference? When we say procedure established by law, we have certain written procedure. We have written procedure. As we know we have three agencies. One is legislature, second is executive, and judiciary. So all these three branches of government have their unique nature of working. They derive their power from the constitution. Constitution gives all these three agencies power to function. So legislature has a power to make laws. Legislature frame laws. Executive implement those laws, and judiciary interprets those laws. As judiciary is the custodian of our constitution, and constitution is the source of power for all these three agencies. If there is any law which takes away the fundamental rights of any citizen, then judiciary will interfere. Judiciary will interfere and it makes those law invalid. It declares those law invalid which is against natural justice or against the common life of people. Like if it take away the fundamental right of any citizen, then citizen can move the court and court will declare such law as void or invalid. So when we say procedure established by law, here Parliament is the supreme body to frame such laws, and judiciary only when the Parliament is against the Constitution brings any law, then only judiciary will intervene, it will interfere and declares such law as invalid. That is procedure established by law. Here the ultimate power to make laws is with legislature. In our case, it is with Parliament. So judiciary cannot unnecessarily question the policies of the legislature. ఒక లెజిస్లేచర్ ఒక పాలసీ తీసుకొస్తే ఆ పాలసీ వెనుక ఉద్దేశాన్ని క్వశ్చన్ చేసే హక్కు జ్యుడిషియరీకి లేదు దీని ప్రకారంగా ప్రొసీజర్ ఎస్టాబ్లిష్డ్ బై లా. ఎందుకంటే ఏదైనా పాలసీ తయారు చేయడం అనేది, పాలసీ తీసుకురావడం అనేది అది ఎక్స్క్లూజివ్ జ్యూరిస్డిక్షన్ ఆఫ్ పార్లమెంట్. పార్లమెంట్ మాత్రమే కొన్ని చట్టాలు తీసుకురావచ్చు. అదే స్టేట్లో అయితే అసెంబ్లీ చట్టాలు తీసుకురావచ్చు. ఈ చట్టాలు కాన్స్టిట్యూషన్కి వ్యతిరేకంగా ఉన్నప్పుడు మాత్రమే కోర్ట్ ఇంటర్ఫియర్ అయి అలాంటి చట్టాలని ఇన్వాలిడ్గా డిక్లేర్ చేస్తుంది. అంతేకాని it will not question the policy of such law. There is a difference. Here due process of law. Here in due process of law, judiciary have active role. In due process of law, judiciary can question the policies framed by the Parliament or legislature. This we have brought from United States of America, where more power is given to judiciary, not Parliament. So here we have judicial activism, judicial supremacy. In United Kingdom, that is in England, we have parliamentary sovereignty. We have parliamentary sovereignty. Much power is not there for judiciary. And as we studied in features of Indian Constitution, our Constitution is a blend of both parliamentary supremacy and judicial supremacy. So both have been incorporated in our Constitution. So that is the reason why our court will become active when there are few laws which is against the will of the people or against the Constitution. So in due process of law, the judiciary can question both Parliament and executive. But in procedure established by law, the judiciary can intervene only when there is a problem with execution of such policies. So here already we have established a procedure, and if only when the executive agency or the implementing body acts against such laws which are framed by the legislature, then only the court could interfere. Here in due process of law, the court or the judiciary can interfere when there is a problem with both implementing agency, that is executive, and also with legislature, that is policy formulation body. So due process of law has a wider scope than procedure established by law. We should discuss a few cases regarding this due process of law. For example, we have Gopalan case of 1950. What exactly happened in A.K. Gopalan case? A.K. Gopalan case versus Madras State, where the Gopalan has been detained. Gopalan was a freedom fighter and he has been detained. So he has gone to court. Then court said, no, state has all the power. State has all the power to detain a person. But there are many cases which has gone beyond after many years. So in Gopalan case, the court did not went against the state, saying that state has legislative power and it can pass any law. But again, after many years, in Maneka Gandhi case, that is 1978, the court has revisited all these things and said that it is not only procedure established by the law, but due process of law should be followed. And since then, from this case, from Menaka case, the court now follows due process of law. That is, the court can also interfere the legislative body when its law are against the natural justice or against the constitution. So here in due process of law, the court will question both policy formulation body and also policy implementation body, that is legislature and executive. We'll discuss this case in detail in our next class. So we need to understand what is procedure established by the law and due process of the law. Due process of law has a wider scope which gives judiciary more power to interpret and to know the thought behind the formulation of the policies, the object behind the policy formulation, not only the policy implementation. So it can also question the object or the reason behind those policies, why the policy has been brought. It is not only how it is implemented, it could also question why, what is the reason for this policy. So that is due process of law, where judiciary has more scope and it has more power to interpret the laws. So protection under Article 21 is available only against arbitrary executive action and not from arbitrary legislative action. Here this statement says that we have followed procedure established by law, because here under this is available only arbitrary executive, that is only for executive, that is implementing agency. Here the court will not question the policies of the legislature. This is before Menaka case. This statement is before Menaka case. Now at present the court also questions the legislature, the court also questions the parliament for the policies it has brought, and it will also question the objective of the policies. If the policies are against the constitution or against the will or interest of majority of the people. So here in procedure established by the law, it only acts against the arbitrary executive action, but not for arbitrary legislative action, because here we have given legislator a sovereign power. Legislator has a sovereign power, that is it can make any law, because we follow a representative form of democracy. We will send those representatives to frame law for the people. So that body, the legislative body, will frame law in the interest of the people. That is what actually we thought of. But as we know, even that small group of people may frame such policies which may be at sometimes against people's interest. That is the reason after Menaka case, court has said that even legislative action should also come under scrutiny, because in due process of law, we not only see the procedure of implementing, but we also see what is actually get implemented. So here both policy and the method of implementation can be questioned by the judiciary. So state can deprive the right of life and personal liberty of person based on law. In some cases the state can deprive. For example, we have preventive detention. Under preventive detention, any person can be detained without proper crime. So if any person, even if he or she has not indulged in any crime, can also be detained by the enforcement agencies and can be held for 2 months. Actually it was 3 months, we have reduced it for 2 months now. because that stops that person to do a crime. It is a preventive detention. That is, the state is preventing a person to commit a crime in future. We have punitive detention. This type of detention is only when a crime is done and the court follows a due process and punishes a person and holds that person in jail or contains him in jail. That is punitive detention. This is after the crime is done, after the guilt is found, and after he is convicted, then only we have punitive detention. But in preventive detention, a person can be held without actually committing any crime, but he may be a threat to the society for that time being, so he can be detained. He can be detained and put in a custody. He can be house arrested, or he may not be let to go outside of that premises. So we have punitive detention. As we have clearly said, state can deprive life and personal liberty based on law. We have a law. Like in section 144 of IPC, we can detain a person. We can go for a curfew such thing. So this is what the judiciary can intervene in case where the state detains a person illegally. That is, even if there is an arbitrary action which is against the law, which is mentioned in many sources, then a person can challenge that detention and move the court. So this is the two important cases. In Gopalan case, the court has followed procedure established by law. After many years, in Menaka Gandhi case, the court has said that procedure established by law can also be misused at some times. So the court said it has to follow due process of law. అయితే డ్యూ ప్రాసెస్ ఆఫ్ లాలో స్కోప్ అనేది పెద్దగా అయిపోతుంది. అది లెజిస్లేటివ్ యాక్షన్ని కూడా క్వశ్చన్ చేసే రైట్స్ వస్తుంది జ్యుడిషియరీకి. అంతకుముందు ఓన్లీ ఎగ్జిక్యూటివ్ యాక్షన్స్ని మాత్రమే క్వశ్చన్ చేసేది ఇన్ ప్రొసీజర్ ఎస్టాబ్లిష్డ్ బై ద లా. డ్యూ ప్రాసెస్ ఆఫ్ లా ఫాలో అయిన తర్వాత ఆ పాలసీస్ ఏదైతే ఎగ్జిక్యూటివ్ యాక్షన్ ఉంటుందో ఆ ఫ్రేమ్ చేసిన పాలసీ యొక్క ఉద్దేశాన్ని కూడా ఛాలెంజ్ చేసే ప్రయత్నం చేస్తుంది ఇక్కడ. సో దీస్ టూ కేసెస్ ఆర్ ఇంపార్టెంట్ టు అండర్స్టాండ్ ప్రొసీజర్ ఎస్టాబ్లిష్డ్ బై ద లా and due process of law. Article 21, as we said, is an important article. Trinity, that is Golden Trinity, with Article 14, 19, 21. These three form the Golden Trinity. So Article 21, that is protection of life and personal liberty. As we said, life is నాట్ జస్ట్ బ్రీతింగ్. లైఫ్ అంటే మామూలుగా ఒక శ్వాస తీసుకోవడం కానీ ఒక ఇన్యాక్టివ్ లైఫ్ని లీడ్ చేయడము అది లైఫ్ అనము. సో వీ హ్యావ్ అ వెరీ లార్జర్ స్కోప్ గివెన్ ఫర్ లైఫ్. లైఫ్ ఈజ్ నాట్ జస్ట్ హ్యావింగ్ అ వెజిటేటివ్ లైఫ్. లైఫ్ ఈజ్, యాజ్ వీ హ్యావ్ డిస్కస్డ్, ఇట్ షుడ్ బి లివ్డ్ ఇన్ అ ఫ్రీ మేనర్, ఇన్ అ ఇండిపెండెంట్ మేనర్, హ్యాపీలీ with various things. And Constitution says that life here is not just living a vegetative life. So here in doctrine of public trust, life here is very larger in scope. To live a life, we need to have a very good environment. That is, the environment where we live should be clean, should not be polluted. That is, we have a right to have a pure air. That is, no pollution, sound pollution, air pollution, water pollution. We have a right to have a safe and pure drinking water. We have a right to have a good roads. We have a right to have a shelter, to have a free legal aid. As these things makes a life living worthfully. So life here is not just living, it should be lived with dignity, with morality and all. So this in MC Mehta versus Kamalnath case, Supreme Court has said that the water, the environment should be pure. So in many cases, even we have seen in Maneka Gandhi case, we have a right to move anywhere. We have the right to go to abroad and also to speak there. So the fundamental right, that is right to freedom of speech and expression, is not only valid in this country, but you can go abroad also, and when you are in abroad can also speak your mind, you can speak your heart. So the right to speak, the right to express is valid not only in this country, but when you go abroad also. That is what given in Maneka Gandhi case. In various judgments, the Supreme Court has added various things in strengthening this article, that is Article 21, right to life and personal liberty. You can demand a government for providing safe drinking water. You can demand a government for providing electricity. You can demand a government also to provide good roads, health, education, good environment for children to play, public parks, all these amenities which adds life to this article, that is life and personal liberty. So here when we discuss section 309 of Indian Penal Code, this section punishes suicide or punishes attempt for suicide. So if any person decides to suicide, that is take his life, that is illegal. So section 309 punishes such person. But when we talk about this, when a person decides to end his life, there may be many reasons for that. Maybe in full depression, a person decides to end his life, and when he has attempt to suicide, it is not crime on part of his action. So he should not be punished because he is in depression and he wanted to end his life. He should not be again tortured by police. So Supreme Court has said that IPC 309 is against natural justice and it should be repealed. Right to live with human dignity. As we said, life living is not just living. That life should have a meaning, should have a dignified life. The livelihood should be a motivation to others. So in various cases, Supreme Court time and again has revisited this article and said that life is not just living a vegetative life, it should have a meaningful life. It should have a colorful life. Every natural thing should be enjoyed. So in many cases, for example, if we take euthanasia, Karunya Maranam, when a person could not live with dignity, such person can end his life. So when we talked about IPC 309, which punishes suicide, and here in euthanasia, for example, a person who is on a treatment, that is medical treatment, cannot live with dignity. Such person could end his life because there may be no chances of their living. This case was, the Supreme Court has discussed this case extensively. In Aruna Shanbag case, Aruna Shanbag was a nurse and she has been brutally raped and she was in coma for many years, and she decided, like the Pinky Virani, who is a journalist, took this case, and the question before the court is, give permission to end her life. So there was an extensive study on this case regarding euthanasia. Here Supreme Court said that life is not just living, it should be lived with dignity. So in Aruna Shanbag case, when she has been in a vegetative state, that is under coma for 42 years, what is the dignity in her life? She could be given permission to end her life. So this is one case where Supreme Court has decided on protection of life and liberty. We also have a case, Naz Foundation. Naz Foundation versus Delhi. This case is about lesbian, gay, bisexual and transgender. So this section is also important. Here life is to choose their life is one of the freedom to choose the way a person could live their life. So here in this case also Supreme Court has done away with all those punishable sections under which a person who has different sexual preferences are punished. So Supreme Court has also ordered the government to do away with such provisions under our sections, be it CRPC or IPC. So like this we have many cases. In one of the case, for example in Common Cause versus Union of India 2018, withdrawal of treatment. That is, if a person knows that he could not be living in future because he was on treatment and there are very minimal chance of his cure, so then he can ask for withdrawal of the treatment. If a treatment is withdrawn or there is no medication, then that person will die. So it's a voluntary asking to a state or any agency to let that person die. If doctor knows that this person cannot be cured, he is beyond the curing or any treatment will not work on him, then the doctor can go for withdrawal of treatment. So that is a life with dignity and death with dignity. He can have the right, he has the right to die with dignity. So these are the cases which strengthens protection of life and personal liberty. Here in Kunal Sahu versus Advanced Medical Care and Research Center, Kolkata, it's in hospital. We have a case, Kunal Sahu case. Here in this case, the Supreme Court has said that the hospital shouldn't act negligence, that is the negligence of staff, doctor or any medical staff. Because of their negligent behavior, if a patient dies, then the compensation should also paid by such hospital. When we talk about compensation, that compensation may not worth a life. ఒక ప్రాణానికి విలువ ఉండదు. ఈ కేసులో కునాల్ సాహు కేసులో కునాల్ సాహు భార్యని హాస్పిటల్లో జాయిన్ చేశారు, కానీ ఆ గవర్నమెంట్ హాస్పిటల్ నెగ్లిజెన్స్ వల్ల తన ప్రాణం కోల్పోయింది. సో ఈ కేసులో కోర్ట్ ఆల్మోస్ట్ 11.5 crores రూపీస్ హాస్పిటల్ మీద కంపెన్సేషన్ ఇవ్వాలని ఆర్డర్ ఇచ్చింది. దిస్ అమౌంట్ ఈజ్ లార్జర్ అమౌంట్ అండ్ వీ కెన్ సే దట్ దిస్ అమౌంట్ ఈజ్ నాట్ ఈక్వల్ టు ద లైఫ్, బట్ there should be a thing where the hospital should manage or they should function in such a way that there should be no negligence from their part to save a patient's life. Now we have seen in many hospitals, corporate hospitals, government hospitals or any health centers where due to the negligence of doctor or medical staff or improper treatment or giving wrong medicines, patient dies. So what is the freedom of life there? How we could have a protection of life in such cases? So because to have a pressure, that is to make hospitals more vigilant, more friendly to the patients, court has ordered to pay 11 crores compensation in this case. Though we can say that this amount will not get that life back, but on part of the hospital, they have to be more vigilant. They cannot just be negligent, which causes a life. So this is the case in Kunal Sahu versus AMC Kolkata in 2013. This case reiterates that hospitals or management shouldn't be more negligent way. They should be more protective towards any patient, irrespective of their social status. We also have a case, that is Safe Life Foundation versus Union of India. Before this case, we have seen that if any road accident occurs and if any person brings that person or that patient to the hospital, the person who has brought such person or patient to the hospital should give his personal information, or he should also be asked by the police to come to the police station and tell all the things, how the accident happened and what was the surroundings there. This has made many person to not stop at that place and just go away. So due to this stringent things, many persons have lost their life due to road accidents. Supreme Court said in this Save Life Foundation that no person should be forcefully said to come to the police station or give their personal information. They can admit that patient to the hospital just telling their basic information such as their name and small things, and they can go to their own destination. So this judgment of Supreme Court is a way to save many lives when any road accidents occur. మనం చాలా సందర్భాల్లో చూస్తుంటాము, రోడ్ మీద యాక్సిడెంట్స్ అవుతుంటాయి. అక్కడ నుంచి వెళ్ళే వేరే ఇతరులు కానివ్వండి, ఆ యాక్సిడెంట్ అయిన పర్సన్ని హాస్పిటల్కి తీసుకెళ్ళడానికి భయపడతారు. ఎందుకంటే అలాంటి రూల్స్ ఉన్నాయి మనకి. ఆ పర్సన్ ఎవరైతే హాస్పిటల్కి తీసుకెళ్తారో వాళ్ళని కూడా వాళ్ళ ఇన్ఫర్మేషన్ తీసుకోవడం కానీ, వాళ్ళని పర్సనల్గా పోలీస్ స్టేషన్కి రమ్మని చెప్పడం కానీ జరిగేది. ఈ జడ్జిమెంట్ తర్వాత సుప్రీంకోర్టు అలాంటివి చెల్లదని చెప్పింది. సో ఆ పర్సన్, ఆ పేషెంట్ ఎవరైతే గాయపడ్డారో రోడ్డు మీద యాక్సిడెంట్లో, అతన్ని నియరెస్ట్ హాస్పిటల్కి తీసుకెళ్ళచ్చు, అంబులెన్స్కి ఫోన్ చేయొచ్చు వితౌట్ గివింగ్ దేర్ ఐడెంటిటీ ఆర్ వితౌట్ గోయింగ్ టు ద పోలీస్ స్టేషన్ ఇన్ ఫర్దర్ థింగ్స్. So this is also an important case which has strengthened the Article 21, that is we can protect our life. So that is Article 21. We also have an important article, that is Article 21A. In many judgments of the Supreme Court, we also say that we have right to life. And right to life is living a life with dignity, living a life with all such factors which could make a person independent, which could make a person creative and helps in the development of the society and to the nation. So when we say right to education, suppose if a person is not educated, what is the meaning of life? For example, if an illiterate person doesn't know anything, he may not enjoy the life fully. So educated person knows the things. He can know what fundamental rights are, what is directive principles of state policy, how he could question the government in some cases. So a basic education is a necessity for a dignified life. Because of this, we have made this right to education as a fundamental right. Before that, we had this right to education in directive principles of state policy. That is, it was not enforceable in court. Any person who is deprived of his education cannot go to court saying that I lost my education, I have deprived of my fundamental rights then. But now in Article 21A, we have amended this and made right to education a fundamental right. Now any person under the age of 6 to 14 is not provided with education, elementary education or secondary education, can move the court. That is, we have free and compulsory education. It is the duty of the state to provide free education for the people between age of 6 to 14. This is a fundamental right, and for this many steps have been taken by the state. 6 నుంచి 14 వయసులో ఉన్న పిల్లలు ఖచ్చితమైన విద్య అది ఫ్రీలో ఉండాలి. వారికి ఉచిత విద్య ఉండాలి, ఉచిత స్కూల్ కూడా వాళ్ళ ప్రిమిసెస్కి దగ్గరలో ఉండాలి. సో వీ హ్యావ్ మెనీ సచ్ థింగ్స్. వీ హ్యావ్ గివెన్ దిస్ right to education a reality after we have brought many laws. We have Sarva Shiksha Abhiyan. We have Sarva Shiksha Abhiyan, where it is compulsory to get enrolled by the students between the age of 16 to 14. Under this, we have midday meal scheme, where the state will provide free food, midday meal scheme. The state, that is the government schools, will also provide free food, free uniform, and give all those supportive things like books and other stationery things, so that the parents will send their children to the schools. So here Article 21A makes it mandatory for any parent to send their wards to the school, and if not, they will be punished for that. Earlier in Article 45 of DPSP, it was mentioned that right to education, but now it has been included in fundamental right. If any person is deprived of this right, Supreme Court will interfere and acts to protect the right to education. So Article 21A is important. It will improve the quality of the citizen. That is, when the person in this age group is educated, he would definitely adds to the growth of the society. So that basic education will definitely, I may not say that everyone will become professionals in their life, but that basic education will definitely improve the standard of living, quality of life, and their family also. So for their growth of their family, definitely education will help. And this also been there in fundamental duties. In fundamental duty, that is in Article 51A, it is mandatory that the parent should provide their children with such environment where they can study, they can grow both physically and mentally. So it is the duty of the parent. Okay, though it is not a fundamental right, but every parent should provide their children with such an opportunity or environment so that they can study. The children can study, and before the age of 6, that is when they are kids, they should be provided with nutritious food for their mental and physical development. So even parents should feel that it is not only government which provides with free schooling, free books, free food, it is also the duty of that parent to provide such facilities so that they could be healthier mentally and stronger physically, so that they could learn. So this article is also important to improve the literacy rate of our nation, which is very poor compared to our neighboring countries. So in this, it is also mandatory to form school management committees, and not only government schools, మనకు ప్రైవేట్ స్కూల్స్లో కూడా 25% of the seats ఇది అండర్ ప్రివిలేజ్డ్ చిల్డ్రన్స్కి కల్పించాలి. సో 25% సీట్స్ అనేది ఏ స్కూల్లో, ప్రైవేట్ స్కూల్లో కానివ్వండి, 25% అనేది పూర్ పీపుల్కి కోటా అది రిజర్వ్ చేసి పడింది, అది కంపల్సరీ యాడ్లో ఉంటుంది మనకు ఆ యాక్ట్లో. సో టీచర్ స్టూడెంట్ రేషియో అనేది 1:30 ఉండాలి. ప్రతి 30 మంది స్టూడెంట్స్కి ఒక టీచర్ ఉండాలి, అంతకంటే ఎక్కువ ఉండకూడదు. సో స్టూడెంట్స్ ఎక్కువ మంది స్టూడెంట్స్ ఉంటే ఆ సూపర్విజన్ అనేది ప్రాబ్లం అయిపోతుంది, ఫోకస్ అనేది తగ్గిపోతుంది. సో ఇట్ ఈస్ మ్యాండేటరీ దట్ వీ షుడ్ హ్యావ్ అ రేషియో ఆఫ్ 1:30. And as I said, private school also should create 25% of the seats reserved for the children who cannot afford. That is, they should be given seats without charging any fee. So this act makes not only the government schools but also private schools, because we have in private schools they may be near to a village or near to a town where the government school may not be in that area. So private schools should also make it mandatory to give free education for the people. That is what we say, it is the social responsibility of that school, because 75% they will charge fee, and it's very nominal that the 25% of the fee, 25% of the seats in the school are given for free. So this is one thing. And in this schooling or in this entire program of be Sarva Shiksha Abhiyan or free books, free schools and all, the sharing of amount is 65:35 by the center and state, by central government and the state government. We also have to establish a national commission for elementary education under this act, so that this act is implemented in a more rational and more practical manner. So we have all those laws which makes this article a true article which builds the life of people so that they could have a beautiful life. As I again say, life without education, life without shelter, life without good health, life without basic amenities like clean drinking water, pure air, nice parks, good road, there is no life. So life with dignity is important here when we say we have right to life and right to personal liberty. So Article 21A adds life to this article by providing free education and compulsory education. We have an act, Right to Education Act, which has passed in 2009, and this act has been implemented from April 1st, 2010. Remember, this was a question in prelims. April 1st, 2010 was the year from where this act has been implemented. So this act, since its implementation, have made many changes. We can say that the literacy rate has increased, but we also worried about the quality of education. When we say free and compulsory education, the government should also have access, the government should evaluate the functioning of the system. There should be quality education. It's not free. The education should be quality education, and the student who have completed his secondary education should be able to do at least some work voluntarily, or there should be a vocational training for them so that they could become a part of labor system. That is, they will become a part of earning. So we should have both quality, and it should match the market of the country. So we have seen this case in Mohini Jain versus Karnataka regarding education. We will be taking Article 22. So in fundamental rights, we have all the 6 rights in Article 19, and then we have Article 20, Article 21A and Article 22 here. So what is Article 22? This article protects illegal detention. So we have an Article 22 which protects against arrest and illegal detention. Previous article, that is Article 21 and Article 20, very close articles. Article 20 was against offences, protection against offences. In that we have studied three types, that is no ex post facto law, no double jeopardy and no self-incrimination. That was one which is protecting a citizen from arbitrary arrest or punishment. Here we are discussing about protection against detention or arrest. So we have in general two types of detention. One is punitive detention and other is preventive detention. So any person can be detained in punitive detention. He can be detained for the crime he does. So here the court can give punishment for his or her detention. In preventive detention, a person can be detained without doing any crime or without any trial. That is on the basis of thing that he may involve in crime in future. That is on the basis of suspicion, any agency, police agency could detain a person under preventive detention. So we have two types of detention. One is punitive detention, that is it's a punishment. Once a person is arrested who is involved in crime, then the court gives him punishment and then that particular person will be detained for the act of crime. So this detention punishes for the crime committed. And preventive detention is only a precautionary. That is, it is not for the crime he has already done, or it is not the crime which he has made or tend to make. Here there is no crime happened, but there may be a chance that if that particular person is free in the society, he may involve or incite any offense. So there is a suspicion on that particular person that if he is free in the society, there he may cause a law and order problem. So on that basis, agency will detain particular person. So it is a precautionary measure based on suspicion. Many cases, many instances where many leaders or many other group of people are detained in this section, under the section of preventive detention. So we may say it's anti-democracy, or it does away, it snatches the freedom of life, freedom of liberty. So why we have brought this section in our constitution or our sources? So preventive detention is also a measure to protect the sovereignty and integrity of the state, security of the state, normal public order or law and order. So it's a precautionary step where the person who is to believe that he may cause some problem, some law and order problem, or he may involve in a crime. So on that suspicion, he may be detained. So that is preventive detention. So we have punitive detention, which is ordinary law. So it's an ordinary law because when we say punitive detention is ordinary law, we have preventive detention, which is not ordinary law. We have preventive detention law there. So under punitive detention, right to be informed. There is a right on the part of the person who has been detained, should be informed by the police why, what is the reason for his arrest. So under punitive detention, a person should be informed by the police. And second thing is, he should be produced before the court or magistrate within 24 hours of his arrest. So a person who is involved in the crime and he is arrested, that particular person should be produced before the court within 24 hours. Here when I say within 24 hours, the time which is taken in traveling is excluded. That is, traveling from the place of detaining a person to the court or to the magistrate is excluded. Here the time is excluded doesn't mean it is, no, holidays and other is not excluded. So holidays are covered in that. So 24 hours is only the traveling time, the journey time is excluded. Otherwise, the Supreme Court has also ruled that if a person who has involved in the crime and the police has detained a person, if he is not produced before the court within 24 hours, he should be let free. So that is the importance of this article, and it is a bulwark, that is, it minimizes the arbitrary action of the police or the state. So when we have in the Constitution mentioned that within 24 hours a person is to be produced before court or before the magistrate, so a police could not held that particular person under illegal detention. So it is against that arbitrary action of police or any enforcement agency. That highlights the freedom of life and personal liberty. One more thing is, if that person is not brought before or produced before 24 hours, then he should be let go. That is, if the police has evidence that that particular person has a made crime, then he should be produced before the court or magistrate, and the court could allow then to have judicial detention, or the court may give orders to give a custody to that person. So that is one where we have punitive detention. In that, a person should be allowed to hire an advocate. He has all the rights to hire an advocate, provided the police should give information to their friends or family members, so that there should be a reason for their arrest, and that reason should be communicated to their family or friends so that he could have legal assistance. Under preventive detention, this detention is not on the basis of any crime. It is on the basis of suspicion. So he has not involved in any crime. That particular person has not involved in any crime, may be involved in past, but this detention is not a punishment for his involvement of past crime. It is a preventive detention which on the suspicion basis detained by police to that person who may involve in future depending upon the circumstances. So that also what we have given in this act is that detention should be communicated to the detainee. That particular person should be communicated, or he should be given reason for his detention. When a particular person has been detained under Preventive Detention Act, the police should inform the reason behind for his detention. And we also say that this detention cannot exceed 3 months. It cannot exceed 3 months. Otherwise, we actually have an advisory board consisting of judges of High Court, where after exceeding 3 months, the advisory board, if suggests that that particular person is a threat to the state or integrity of the state, then this time period could be increased. Otherwise, without any advice from the advisory board, the maximum limit is 3 months for any detention under Preventive Detention Act. Actually, Parliament has made a rule. It has decreased this time to 2 months, but it has not been implemented. So at present, we have this limit of 3 months. Any preventive detention is below 3 months only. It should not exceed 3 months unless advisory board suggests on the basis of security of the state, on the basis of defense, on the basis of sovereignty and integrity, on the basis of law and order. So this is one thing. In Parliament, it is under concurrent list, that is, on preventive detention, both state and center could make laws. As I said, center could make laws on preventive detention, on defense, on sovereignty and integrity of the state, and state can make laws on preventive detention on the ground of law and order, on the ground of maintenance of essential services, etc. So both Parliament and state assemblies have the right to make law on preventive detention. That is, we can say that it is under concurrent list where both Parliament and state legislative assemblies could make law. So we have many such acts, many such law. We can say that Preventive Detention Act has been most popular or most unpopular. It has been misused several times. Many innocents have been detained on the basis of suspicion. So we can also say that this Preventive Detention Act has abrogated the fundamental right of life and liberty. We have seen many circumstances where one political party has started exhibiting their vendetta on other political parties or members of other political parties. So it is basically most unpopular, misused act. Many intelligentsia, many lovers of democracy have condemned this and they want to repeal such draconian acts. On that basis, many such acts has been gradually repealed. So what acts we had in that? Maintenance in Social Security Act, that is MISA, National Security Act, TADA, Terrorist and Disruptive Activity, Prevention of Terrorism Act, POTA, Prevention of Black Marketing and Maintenance of Essential Services Act, MISA Act. So these were the acts. Few of them has been repealed, few of them are still continuing. But because we know for a peace and harmony of the society, for a stable law and order, we need to have such laws where it acts as a deterrent against the person who wanted to create unstable or who is a threat for the security and integrity of the state. So we ought to have such laws, but we have to again use only in such circumstances where we are necessarily needed. So as we have discussed, under fundamental rights, that is right to freedom, we have important articles. Article 19, protection of 6 rights. What are these 6 rights? Actually, we had 7 rights in this. We have repealed right to property. That is Article 19, 6 rights: freedom of speech and expression, freedom of assembly, that is freedom to gather together without any arms, peaceably gathering. Third is freedom of forming associations, unions, cooperative societies. That is, a person or a group of person could form a union or association. Next is freedom of movement. Freedom of movement throughout the territory of India. Any person, any citizen of India could move in any part of the India. We have some restrictions. We'll discuss that. Next is freedom to settle. A person could settle anywhere. He could buy property, buy a home for him, his family. So he have all the rights. It's his freedom to settle anywhere. Next is freedom to occupation. Freedom of occupation, freedom of profession, freedom of business, trade. So he can do any business based on his eligibility. So we have all those 6 rights under Article 19. We have all these rights mentioned under Article 19 of Clause 1. On the same hand, we also mentioned few reasonable restrictions under Article 19 Clause 2. So the state could restrict these fundamental rights on certain grounds. So that is also mentioned in the Constitution. What are those grounds, generally speaking? Grounds like sovereignty and security of the state, sovereignty and integrity of the state. We have contempt of court. We have decency and morality. We have defamation, incitement of offences. So on these grounds, the state can restrict these right to freedom. And the state says that we are restricting, we are providing these restrictions because of stable law and order. We need to have a stable law and order. Because when a person has given absolute freedom to do anything, he may sometimes causes problem to the society, or he may indulge in some activities which actually avoids or which makes others' fundamental rights invalid. So on that basis, looking at the larger section of the people, interest of the society, Constitution itself given few grounds for restriction of these fundamental rights. As we already said, fundamental rights are not absolute. They are not absolute. So absolute in sense, there shall be some restrictions placed on those rights. That is one part. And in Article 19, we have done with right to freedom, that is protection of 6 rights. Article 20, protection of in respect of conviction for offences. As it's just a revision type thing, we have 3 things here in protection in respect of conviction of offences. And what are the offences? Here offences means if any person indulges in offence or a court should punish a person. Here we have 3 types. That is, no ex post facto law is applicable there, no double jeopardy, no self-incrimination, as we have already had discussed this in our class. We have protection of life and liberty. 2 important things here, one is life and one is liberty, that is under Article 21. We have added this Article 21A, that is right to education. Earlier we had this in Directive Principles of State Policy under Article 45. Now we have made it a fundamental right, that is every children under the age of 16 to 14 years have to be enrolled in some school. So that given fundamental right, so that there should be no child labor, the literacy rate should increase, and it will definitely have a stable society, because lot of crimes are being made where we don't have education. So right to education is an important factor. And as I said, protection against arrest and detention. In this we have 2 things, punitive detention and preventive detention. So by this Article 19 to 22, we have finished right to freedom. Today's our topic is fundamental rights, ప్రాథమిక హక్కులు. It is a very important topic in constitution and we would be expecting many questions from these areas. ఫండమెంటల్ రైట్స్ అనేది చాలా ఇంపార్టెంట్ టాపిక్ ఎగ్జామ్ పాయింట్ ఆఫ్ వ్యూలో. అది యూపీసీ కానివ్వండి, స్టేట్ సర్వీసెస్ కానివ్వండి, ఏ బ్యాంకింగ్ ఎగ్జామ్కైనా, ఏ కాంపిటేటివ్ ఎగ్జామ్స్కైనా, జనరల్ స్టడీస్లో, ఇండియన్ పాలిటీలో ఫండమెంటల్ రైట్స్ నుంచి మేజర్ క్వశ్చన్స్ మనకు కనిపిస్తుంటాయి. అండ్ ఇట్ ఈస్ ఆల్సో వన్ ఆఫ్ ద ఏరియా వేర్ we could get confused easily. Reason being, we have to remember most of the articles, and every single article in fundamental rights are such a clause that we would be easily carried away or we would land in answering wrong questions. So here one need to understand the basic concepts of fundamental rights. One have to compare one fundamental right with other fundamental right, and if possible one have to remember all those articles, very important articles which we generally see in question papers. So ఈ ప్రాథమిక హక్కులు అనేది మన కాన్స్టిట్యూషన్లో చాలా ఇంపార్టెంట్ పార్ట్, and we would be dealing today what fundamental rights are, introduction, basic features of fundamental rights, and we would just carry on with our classes on fundamental rights. So what are fundamental rights? See, we have two words here. One is fundamental and rights. So why we call this section as fundamental rights? See, one thing is we call it as fundamental because these rights, the rights which are in part 3 of the constitution, these rights are guaranteed by our constitution. Fundamental rights are guaranteed by our constitution, and as we know, our constitution is fundamental law of the land. Because constitution is the fundamental law of the land, and the same constitution guarantees rights, that is the reason why I call them as a fundamental right. That is one view, one approach. The other being, we also call these as fundamental rights because these rights enshrined in the constitution will enhance or will help each individual or every citizen of the nation to develop their overall personality, be it material, be it intellectual, spiritual and all. There will cater us to develop an individual and give us an overall development. That is also one of the reasons why we call them as fundamental. ఈ ఫండమెంటల్ రైట్స్, ప్రాథమిక హక్కులు ఒక మనిషికి ఒక ఓవరాల్ డెవలప్మెంట్ని ఇస్తుంది. సో దట్ ఈస్ ద రీజన్ వై కాల్ దెమ్ యాజ్ ఫండమెంటల్. ఆల్ సార్ట్స్ ఆఫ్ డెవలప్మెంట్, ఎడ్యుకేషనల్, ఇంటెలెక్చువల్ డెవలప్మెంట్, స్పిరిచువల్ డెవలప్మెంట్, ఎకనామిక్ డెవలప్మెంట్, అంటే మెటీరియలిస్టిక్ కూడా ఇవి మనకి చాలా హెల్ప్ఫుల్ అవుతుంది. సో ఫండమెంటల్ రైట్స్ ఆర్ mentioned in part 3 of the constitution. Important, part 3 of the constitution from article 12 to 35. We have these rights mentioned in part 3 of the constitution from articles 12 to 35. Initially we had 7 fundamental rights. But one fundamental right, that is right to property, has been deleted from the constitution. Now we have only 6 fundamental rights. So what is the basic of these fundamental rights? What had made our constitution makers to enshrine, to keep these fundamental rights? Because every individual, as we are democratic country, every individual should have some rights for their existence, for their growth, for their development. And if an individual develops, he will contribute for the development of any nation or any country. So fundamental rights not only gives fundamental rights or a strength, a power to an individual, it would also contribute for the development of entire country. That is the reason why we call fundamental rights as Magna Carta of India. So what is Magna Carta? In British Constitution we have a great charter. Magna Carta is a great charter. You may also find a question in any question